Amy.
Okay. Good morning, everyone. Welcome to today's Committee of Bar Examiners meeting. It's 9 a.m. and I'd like to call the August 19th meeting of the Committee of Bar Examiners to order. Is Mr. Angelis, are you available to please take the roll? Or is it you, Ms. McFarland?
I will be taking roll.
Okay, great.
Alex Lawrence,
Here?
Dr. Bolton.
Here. Could you hear me?
Yes, we can. Thank you. Robert Brody,
Here.
Dr. Cow,
Here.
Alex Chan, Jim Efting.
Alex is here, sorry.
Thank you. Kareem Gangora.
Devin, there's some members in the attendee pool to be promoted.
Okay, let's promote them. I see that is Kareem. Promote.
And Mr. Efting is there too.
We're just taking roll. Jim Efting.
Yes, I'm present.
Thank you. And Kareem Gangora.
I'm here.
Thank you. Dolores Heisinger.
Here.
Judge Herman.
Here.
Michael Asiri.
Here.
Larry Kaplan.
Here.
Paul Kramer.
Here.
Esther Lynn.
Here.
Bethany Peak.
Here.
Vince Reyes.
Here.
Judge Torrealba. David Torres.
Here.
Dr. Wilkinson. We have a quorum.
Thank you. Next item on the list. So as noted on the agenda for today's meeting, public comments during the meeting will be limited. Members of the public wishing to comment were encouraged to submit written comments prior to the meeting to ensure that the committee would have time to consider those comments. The committee has received and read all the written public comments. We thank you for that. The committee coordinator will attempt to call members of the public in the order that they appear. To facilitate hearing as many members of the public as possible, I encourage you not to repeat points that were made by previous speakers and to allow the committee the time needed to deliberate on the important topics that we will be discussing today. We will be limiting public comments to 2 minutes per person. For those of you who are participating via Zoom video, you should have a function for virtually raising your hand. It's a hand icon and should appear at the bottom center of your screen. If you wish to make a public comment, please click on that. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. The coordinator will call members of the public in the order that they identify raised hands and will enable the microphones of the speakers. As discussed at our last CB meeting, we'll be taking public comments from law schools in a different format at today's meeting. Law school deans that would like to make public comment during their corresponding agenda item will be allowed to do so once their agenda has been presented by the subcommittee chair and staff. Law school deans will have 5 minutes to speak at that time. Are there any public comments that wish to make a comment? Ms. Nunez.
We have 5 now members of the audience that would like to make a public comment. So starting with Terry, you have 2 minutes.
This is Terry Andrew Levine. Hello.
Hi, we can hear you.
Oh, you can hear me. Okay, fine. I'm here to comment on the San Francisco Law School request to continue or get a continuance on their plan to improve their bar passage rate. Some of you may not know me or ever heard from me, but I graduated from San Francisco Law School in 1969. I was president of the State Bar of California in 1987, 1988. I was on the Commission on Judicial Performance in 1989, 1990. I teach trial practice advocacy at Stanford and USF now. And my law school education back in 1965 to 69 was excellent. The law school itself is the oldest law school, I believe, in the state of California, and it's graduated some impressive people, including one of the governors of the state of California and several elected officials that have common names. I think this law school, with its history from way back early in the 1900s, deserves an extra opportunity to qualify itself on the bar passage rate. There are plenty of people that are highly qualified trial lawyers. I've been practicing trial for a trial lawyer for 52 years, although I'm retired now. I've tried over 40 cases to jury and many, many to judges, and I've gotten $1 million verdicts. So it's not as though this law school hasn't produced people who are able to practice law in the state of California. By the way, I also teach and lecture on professional ethics in numerous law schools around the state. So there are graduates out here from this law school that are proud of it and want to see it get an extra chance. That's my comment.
Thank you. Our next public comment is from Travis.
Thank you for giving me some time to speak. My name is Travis Alexander. I'm also a graduate of San Francisco Law School, I graduated in 2014. I'm here to speak in favor of San Francisco Law School and extending the probationary period to give the school another chance to keep working towards bringing our bar pass numbers up. San Francisco Law School was one of the first, if not the first, law schools to actively encourage and recruit enrollment of people from groups that are traditionally marginalized, not only throughout the state, but throughout the country. This is a role that has been near and dear to the school throughout its entire tradition. And this is something that we're losing as smaller law schools are dropping by the wayside. It's something that needs to be protected, and that San Francisco Law School holds a unique position in being able to take people who would not be able to enter other law schools and give them a chance to join the profession. I have heard our law school described as a scrappy school for scrappy people, and that's something that I absolutely love. We turn out a lot of attorneys who are very passionate about fighting for justice for their clients. I work in personal injury at a personal injury firm as a case manager currently, and I see firsthand that there are many members of our profession who do not take the passion for justice that I see from our alumni. And this is something that is very sad that I see and is a disservice to all of the people of California. We need more people who are coming out of this law school with passion to be able to fully represent, provide that access to the court system, to the legal system that people so desperately need. There have been many changes made to the school recently. Our current dean has been fighting very hard and working closely with the university to get additional resources so that we can turn this ship around. But everyone knows it takes a long time for these ships to turn. We're already starting to see the results, and we're asking that we have some additional time so that we can finally see some of these changes come to fruition, bring San Francisco Law School back to the glory that it's always been, and make sure that we're here to provide that access to a legal education that is so necessary for so many people who wouldn't have it otherwise. Thank you for my time.
Our next public comment is from Rhiannon.
Yes, can you hear me?
We can, thank you.
Hi, my name is Brandon Ross. I'm a graduate of San Francisco Law School, and probably even more importantly, I am born and raised San Franciscan. Graduated undergrad from Claremont Colleges. I could have attended any law school in the country, but I chose the San Francisco Law School because in growing up in San Francisco, I was able to experience and witness the work of the law school, the graduates that came out of the law school, the judges that are serving on our bench. I currently work for the District Attorney's Office for over 32 years. San Francisco Law School has a tradition. In our country, tradition has always mattered. The fact that we've been around for 100 years speaks volumes to the type of work and the commitment that has been encompassed by not only the school, but the graduates that have come from this school. As you consider what's going on in the current state of America as it relates to our law school, please consider we had a pandemic that no one could have seen coming that has rocked and negatively impacted the lives of the student body, the lives of the faculty, as well as the culture of not only our school, but other schools as well. We ask that you please consider continuing the tradition of the San Francisco Law School by providing the opportunity for more time to take care of the bar passage rate to the acceptable levels by the state bar. Dean Weimer has done an excellent job, but he is working from behind the 8 ball with what this pandemic has done to us. But he has made tremendous strides since he has come into play in our school. I urge you, I implore you to please give San Francisco Law School an extended opportunity to right the ship and continue to make the state bar proud of our work. Thank you for your time.
Thank you. Our next public comment is from Donald.
Yes, good morning. Can you hear me?
We can, thank you.
Yes, thank you for the opportunity to speak. I am a proud and recent graduate of San Francisco Law School, San Diego campus, and I just sat for the July bar. None of that would have been possible if it wasn't for the law school. I started my law school career at an ABA law school. However, I decided San Francisco Law School was the best fit for me. In my first semester, the negative impact of having a revolving door of deans was apparent. However, that all changed once Dean Weimer took over. There must be accountability for schools. I get that, especially law schools, and I don't make light of that. However, I respectfully ask for you to consider the fact that San Francisco Law School exists partially to give a chance to students that won't normally have a fighting chance at entering into the law field. Dean Weimer has brought changes that has given the law school an ABA quality. I can say now that the offering at San Francisco Law School is exactly on par with my ABA experience. That wasn't always the case, but now it is. During my time at the law school, I have witnessed students that would have never been accepted into an ABA get the attention they needed. And some of them eventually went on to graduate and will or already have passed the bar. I know what I just said might just sound like words to you. However, those students would have never became what they are today if it wasn't for San Francisco Law School. However, as we all know, struggling to pass the bar is universal. San Francisco Law School gave me every resource I needed to be competitive for the bar. The changes will take some time to mature and become tangible, but everything is in place. Please let the progress of the school in the last few years guide you. The school mission is important to the legal field, and the potential is unlimited. Please give the changes time to work.
Please wrap up your final thoughts.
Thank you. I don't believe there's another law school that has went through what San Francisco Law School have went through. I just want to thank you for your time, and please look at the lives that the school has changed. Thank you.
Thank you. Our next public comment is from Candy.
Hi, good morning. Thank you for letting me speak today. My name is Candy Smallwood. I am a staff attorney and clinical supervisor at the East Bay Community Law Center, as well as a UC Berkeley lecturer. I am a proud alumni of San Francisco Law School class of 2012. I'm speaking in support of extending San Francisco Law School's probationary period. When I think about defining moments in my life, I think of San Francisco Law School. I never dreamed that I could become an attorney. I grew up in public housing in San Francisco, and my parents' dreams for me were to work at the post office or become an LVN through the City College of San Francisco. My grandmother and SFLS believed in me. Those were the hardest but most rewarding 4 years of my life, working full-time at a credit union and going to law school at night. San Francisco Law School and my grandmother, who couldn't afford an ABA tuition, but could gladly afford my SFLS tuition, gave me a chance. Ever since I graduated, I have been working to make a difference in the lives of others and mentoring San Francisco Law School students that have come after me. It's amazing to see what graduates of SFLS have done with their degrees, the lives they have touched, and the differences they have made. If San Francisco loses their accreditation, it's a lost opportunity for others to have an affordable, quality legal education in the Bay Area. And future law students who resemble me, a low-income woman of color, will not have a chance to change lives. The school, professors, and many alumni are all in this to help raise the bar pass rate. I tell my students all the time to send me essays, and I get them. San Francisco Law School has invested in bar exam preparation programs, but just as seeds are planted and need time to grow, SFLS needs time as well. But the school has the tools, ideas, and the support. All that's needed is more time. Please extend the probationary period. Thank you.
Thank you. And our last public comment is from Natalia.
Hi, my name is Natalia Malashkina. I'm a graduate of San Francisco Law School, class of 2012. I am a practicing immigration lawyer. I would like to say that San Francisco Law School is an opportunity school. It gave opportunity to single mothers to become lawyers, to minorities, to people who come from backgrounds which do not allow them to work full-time and not work. I myself worked full-time during the day and attended San Francisco Law School at night. As an immigration lawyer, I see that our law school produces a lot of immigration lawyers who are really, really good, and we touch lives of people who otherwise would not have legal representations. Sorry, I'm pregnant, so I'm quite out of breath. I'm heavily pregnant at this point. So we produce a lot of immigration lawyers, and we touch thousands of lives through consultations, through helping women who have been in abusive relationships, who are escaping persecution from other countries. If San Francisco Law School loses accreditation, we will lose lots of future immigration lawyers who will touch thousands of other lives. And a lot of people who otherwise wouldn't be able to work as immigration lawyers. Immigration law is not a very well-paid area of law. A lot of elite lawyers cannot afford paying a huge ABA tuition and then go into a field which does not give huge salaries, right? So our law school is the place which makes lawyers who can serve communities, who can help underrepresented people. And if you look at our graduates, disproportionate amount of immigration lawyers. Dean Weimer made great changes. We did have difficulties at the law school with the change in ownership of the school, but they are doing great things right now. They are on track of becoming a very solid, well taken care of school. And I wish that Cal Bar gives a chance to our law school to maintain accreditation and continue producing great lawyers. It's been hard for everyone during pandemic. Give us a little bit of a chance.
Thank you, Natalia.
Extend the period. Thank you so much.
I believe there are no more public comments. Is that right, Ms. McFarland?
That is correct. We had one more person just raise their hand. Okay, for our final comment, Erica, you have 2 minutes.
Hey, good morning. San Francisco Law School is made up of working adults. As you've just heard, as a working compliance professional in 2017, I had very limited options to earn a JD without giving up my career. I just finished in May of 2022, and I have sat for the July 2022 exam, and I'm awaiting results. I hope that this committee extends the probationary period until our results are received. It is quite difficult to balance full-time work and studying 3 to 4 nights of a week. Most of the students spend 4 nights in class and have only Friday, Saturday, and Sunday to read all of to prepare for their 4 evening classes. I did this at a somewhat longer time frame than the rest of my peers who are all also working adults and have held many internships and clerkships throughout the last few years. I did expedite my studies during COVID, but I was also caregiving for my mother, and I also was working full-time, and myself was able to get an externship opportunity approved through my employer. Studying for the bar was I took, and in my public comment, I've given the course load of bar prep that I performed ahead of the bar. I worked 2 days of the week during July in order to make those study hours. And I can strongly say that had I studied twice as much, I would not feel as prepared as I felt on that particular day with all of the support that I had received from the SFLS community. So thank you for taking my public comment and making this important decision. I hope you choose to extend our probationary period at least to let the 2022 graduates results come in first.
Thank you, Erica.
Thank you, everyone, for providing your public comments. The next item on our agenda is approval of the June 17th, 2022 Committee of Bar Examiners public meeting minutes. Attachment 0100 has the details of those minutes. Is there a motion?
This is Robbie. I'll move to approve the minutes.
I will second it.
Thank you,
Torres.
Mr. Torres.
Roll call vote. Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow, Dr. Cow.
Yes.
Thank you. Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Abstain.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn, Bethany Peak,
I'm going to abstain.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilkinson, and Esther Lynn. The motion passes.
Thank you. The final item under the chair's time is the outgoing members, recognition of outgoing members, attachment 0101. Specifically, we have Mr. Michael Asiri and Judge Toriaba, whose terms will expire on October 1st. And with us today is Mr. Asiri. And before I invite other members to comment, I want to personally thank you, Mr. Asiri, as well as Judge Toriaba, for your service on the committee. I've always appreciated your engagement and feedback and dialogue. You and I have served on the committee for a number of years, and even on some of the subcommittees. So again, I want to thank you for all that you have done over the years in your comments and feedback. But I invite other members, if they wish, to comment. And what I'll do, I'll read the specific citation for those who may be calling in by phone and can't necessarily read it. This citation is presented to Michael Asiri by the Committee of Bar Examiners of the State Bar of California in recognition of his retirement from the Committee of Bar Examiners after 4 years of outstanding service as a committee member and his distinguished service to the legal profession in California. I also believe we have another one for Judge Torrealba. And this citation is presented to Honorable Shelley Torrealba by the Committee of Bar Examiners of the State of California in recognition of her retirement from the Committee of Bar Examiners after 4 years of outstanding service as a committee member and her distinguished service to the legal profession in California.
Hey, this is Robbie. Alex, can I jump in real quick?
Absolutely.
I just want to say, having been the CBE chair until Alex pushed me out and replaced me, it was such a pleasure to work with a committee member like Michael, who over the years of us working together has become a friend. His answer was always yes to any request to pick up another item on a committee when a member was not available. And he brought a very thoughtful and unique perspective to our discussions at every meeting, something that was really welcome and appreciated by all of us, even if we didn't say it out loud. I often look to Michael to get his take on things, and he always had a perspective that was well worth sharing with the group. Michael, you are really going to be missed. And committee members, Michael is being termed out because he is a new admittee member and he's no longer that new, so that that excuse will no longer keep him on. I spoke with Shelley yesterday. She is caring for her older parents who are out of state, and that's where she is today and why she can't be here. So from me and my bird, I want to say thank you, Michael, for your service and best of luck in whatever comes next.
Thank you, Mr. Brody.
Mr. Chair, if I may.
Absolutely. Go ahead, Mr. Mcgora.
Thank you, Mr. Chair. And I just want to say, Michael, thank you for your friendship over the past couple of years. It's been very enlightening to learn more about your background. And I really appreciate your commentary and just having someone that I could, really engage with ideas and learn more about your story, which is very inspirational and very impactful. So I know we're going to stay connected, but I do want to thank you for your service in this committee. And I also want to thank Judge Torrealba for everything and really just giving a different perspective to this committee and really honing in on being very supportive of our efforts. So they're both going to be missed, but I wish them both the best.
Thank you, Mr. Gongora. And before we move on, Mr. Seri, while you're not required to make any comments, and I don't want to put you on the spot, but would you like to make any comments?
Thank you all for the remarks. I just had a splendid, wonderful time working for the Committee of Bar Examiners. For anyone in the audience attendees, I highly encourage to apply for this or other State Bar California positions. It's just such a rewarding experience. It's something that's very truly impactful in terms of having a say and being able to divulge and contribute unique background, experience, history, and knowledge and thought perspectives about how you can proceed and improve the, at least for the community here, the legal field as a whole. It's sad that I'll be terming out, but I'm hoping that I have other grander ambitions on the horizon, and I'm hoping that I get appointed to those, or if not, continue being just a beacon of excellence. I can say that I was recently appointed to be on the ABA's Access to Justice Commission. So that's an exciting venture for the next upcoming term year of 2022 to 2023. So at least I have something amazing for that. Nonetheless, it's something in which is truly been amazing to work with such wonderful people, such wonderful staff, and other members here and officers. It's just truly a blessing experience. And just thank you for this opportunity.
Thank you, Mr. Aseri. Now, there is a proposed recommendation, a motion. Would someone like to read that?
I'll
and make the
I'll make
motion?
the motion, Mr. Chair.
Is there a second?
I'll second the motion.
Can we have roll? You're muted.
Seconded by Dolores to confirm.
That's correct.
Thank you.
Can we read the motion? Sorry.
Sure, I'll read the motion. It's recommended that move that the committee's gratitude be extended to outgoing committee members Michael Aseri and Judge Shelley Toriaba. A citation will be presented to Michael Aseri on behalf of the Committee of Bar Examiners of the State Bar of California in recognition of his outstanding service after 4 years of service and his distinguished service to the legal profession in California. A citation will be presented to Judge Shelley Toriaba on behalf of the Committee of Bar Examiners of the State Bar of California in recognition of her outstanding service after 4 years of service and her distinguished service to the legal profession in California.
Roll call vote. Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gongora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman, Michael Aseri,
Abstain?
Larry Kaplan,
Yes.
Paul Kramer,
Well, if Michael still wants it, yes.
Esther Lynn,
Sorry, I was
Yes.
just wasn't sure if I'm allowed to vote for myself. But I can vote for the judge, of course.
Esther Lynn,
Yes.
thank you. Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilkinson, and circling back to Judge Herman. The motion passes.
Thank you. Moving on to the next part is the report from the director, Ms. Nunez.
Good morning, everyone. I'm here. I have I'm not feeling 100%, which is why I'm not on camera. I'm hanging in here. So one of the first items that's on the agenda is the schedule for the next CBE meeting. That is going to be our first in-person meeting after a couple of years of remote meetings. So this is a big moment for us. It's a one-day meeting that is scheduled in person at the Los Angeles State Bar office. As many of you know, it is October's our orientation meeting date. So we'll be having an orientation that morning before we start the session. We're also ensuring we're going to keep Zoom available because it facilitates public comment. And in the event that anybody's unavailable, to attend in person. So again, October 14th in Los Angeles, one-day meeting. And those who cannot make it will be able to join via Zoom. Any questions?
Yeah, I have one
Larry Kaplan here. Is the orientation session in the morning, should existing members attend that?
Yes, we open it up to everyone.
And we're expected to fly in and fly out that day, I guess.
I think you could come in on the Thursday evening, and I'll send information related to that in terms of making travel arrangements.
Okay, and because the morning will be taken up with orientation, we should probably expect that we might go until 5 in the afternoon as far as making travel plans goes.
Yes, that's correct. Any other questions? Okay. All right. So the next item is the key statistical indicators. And this is in a standing item that where I cover areas where we've experienced a 20% change, whether an increase or a decrease when compared to last year. And this is looking at the months of June and July 2022. And there are about 6 areas that have experienced that level of change. Starting with applicants placed on the motion. As you can see here, and seeing the statistics that were attached to this item, there's a representation of 70% less this year compared to last year. And this is really a result of the late bar exam release from the 2020 July bar exam. As you may recall, in July 2020, that bar exam was postponed to November of 2020, which meant that the results were released in 2021. So anybody who passed that 2020 exam was counted in 2021, and that explains a large differential in this item. But in terms of the bar exam in general, we've experienced a lower number of people applying for the exam. As you can see here, we have 21.3% less applicants for the general bar exam, and about 28.6% less of attorney exam applicants for the bar exam. And also we've had a decrease in the number of first-year law students applying for the exam. I'm sorry, in terms of the number of applications for the first-year law student exam, 57% less. As for moral character, we had a decrease of 44% in the number of moral character extensions. And some of this may be due to the fact that last year we had the provisional licensing program open and active, and people needed to keep a moral character application active in order to qualify for that program. And that could explain why we have a decrease this year, as that program is now ceased, or the application period for that program has now ceased. And now, and the last one is an increase, and this has been constant for the past year, is an increase in the number of MJP applications by 53.6% for June, July 2022 compared to 2021. And multi-jurisdictional practice includes registered in-house counsel, registered legal aid attorneys, and registered military spouse attorneys. Any questions then about the key indicators?
Yeah, I have a question. Any explanation for why the fairly dramatic decrease in activity?
In the bar exam, or I think for
just
the
across the board, they're all.
Oh, yeah. So I explained the applicants on the motion about the delayed results. For the bar exam, I mean, the one thing that is different about the 2022 exam compared to 2021 is that we went to an in-person modality. So one difference potentially could be the fact that in 2021, we had high numbers of people taking the exam because they did not need to travel. You could take the exam anywhere, versus now you have to come in person. It could contribute to a lower number of people taking the exam, not wanting to travel, not wanting to take this exam in person potentially. I already talked a little bit about the moral character extensions, and with the first year law student exam, this has been we've had a steady decline in the number of people taking that the first year law student exam, and I just think this is part of that decline in general. Any other question? Okay. All right, next slide, please. All right, so we talked about this at our last meeting, but in May, the court issued an extension of the PLL program. It's now scheduled to sunset in December 31, 2022. And applicants are still required to meet all of the educational requirements, the licensing requirements, those in the expanded pathway in order to get fully licensed. Those that are in the PLL program as based on their graduating cohort are still required to also meet other educational requirements that are required for PLL graduates, participants, and also those in the expanded pathway need to continue submitting and tracking their time logs, and those time logs are also still required from their supervisors along with a positive evaluation. At the time that this was extended, the cohort that remained was 215 in the original pathway and 147 in the expanded. Next slide, please. And these are statistics as of August 15th, 2022. As you can see here, we only have about 300 active PLL participants as of this date. About 1,166 have been admitted to the bar. As you can see here, 629 of those that have been admitted are people who sat and passed the bar exam. These are the ones that enter the PLL based on graduation date, while another 537 that participated through the program expansion have been admitted to the bar because they've worked over 300 hours and received positive evaluations from their employers. And these again are applicants that had achieved a score of 1390 on a previous bar exam. And they've also met all of these applicants have met all of the licensing requirements. That is sitting and passing the MPRE, having a positive moral character determination, and all of the other licensing requirements. So the remaining cohort also includes 15 suspended applicants and 104 terminations. And just as a reminder, suspensions result typically from not having satisfied a moral character requirement, and that applicant perhaps is appealing that determination. And terminations occur as a result of either a rule violation that is not meeting all of the rules or regulations of the California Rule of Court 9.49 and 9.49.1, such as not completing the new attorney training program. So altogether, a total of 1,585 applicants participated in the program to date. And next slide, please. These are our statistics in terms of those that have been admitted to the bar through the pathway. Of the 537 applicants, this represents the race and ethnicity of those. And as you can see here, the vast majority are white, 42.8%, followed by Asian, 18.8%. These are the top three largest groups represented here, and Latinos at 17.5%. Next slide, please. Of those admitted also, this is the schools that they come from. 36% come from ABA law schools, and 26.6% come from CBE accredited law schools. Next slide. And in terms of gender, about 55% are female. All right. Any questions about the PLL program? All right, with that, then we'll move on to the July 2022 California bar exam, and Audrey will be providing an update on this.
Good morning, everyone. Well, as you know, the July bar exam was Tuesday, July 26th and Wednesday, July 27th, with some accommodated applicants testing over the remainder of that week. We had 15 total testing sites. We were testing all in person, as Amy mentioned, and 6 of those testing sites were for our accommodated applicants. We had approved 8,148 applicants to come to the exam, but we had 588 no-shows and 17 partials. So total attended was 7,543 for the July bar exam. So that's sort of by the numbers about the exam this past July. Any questions?
Hey, Audrey, this is Robbie. When you say partials, are those applicants who begin the bar exam and then leave before the exam's completed?
Yes. Yeah. So people who did not complete the exam.
So they actually checked in on the first day and began the exam, and then for whatever reason chose not to continue.
Yeah, that's right.
I see. I just want to also say it, and I have shared my comments with Tammy and Amy, but I did attend the Pasadena exam, visited the exam site this year, which had a record number of over 1,200 applicants, and it was extremely well organized. A lot of deference was paid to the applicants to make sure that they had everything that they needed. It was very, very, very well run for such a large amount of people. Very impressive management of that exam site. I don't know who else on the CBE attended a bar exam, but I'll tell you it was really something to see. To have an in-person exam move very smoothly, large numbers of people seated and ready to take the exam with proctors ready to observe. It's just very impressive. So hats off to everyone on bar staff for putting this in-person exam together.
Thanks for saying that, Robbie. I think it's a huge lift by our staff to go out and work at these 15 test sites, and for Tammy's team to organize and put on the in-person bar exam. And we also had many other state bar staff volunteer to work across different departments. So I want to thank everyone. Thanks for saying that, for the effort to make the exam possible.
Yeah, I'd just like to echo Robbie's comments, because I went to the site in Oakland at the convention center. And this is the second time I've been there. And similarly, the organizational efficiency was just, I think, tremendous. And the staff took time to, give me a tour and show me what was going on. And there's a lot that goes on just behind the scenes, which I think, contributes a lot to how this is so smoothly run. And, you're able to, if there's anyone here who hasn't attended yet, you're free to walk around and observe. I try to be as discreet as possible, so I'm not one other body that's kind of in the way of people's concentration. But it was really a great experience, and I commend the entire staff and all the volunteers and the proctors who made that happen.
Thank you, Vince. And thanks for going to check out the Oakland site.
And I checked out the new Anaheim site, as well as the testing competitions for the Anaheim site as well. Both of them were running beyond efficient. I was impressed by the staff working at those sites, and it was just a wonderful experience to just to check around, see how things are run, how they handle certain situations and matters that come up. It was just definitely a wonderful feeling just to finally see that there's a regular testing site in Anaheim after all these years.
Thank you, Michael. That's all from me.
Okay. This next item is an update on the rules revision initiative. So we've talked about this at via our goals in some of our subcommittee goals. This process began as part of the Office of Admissions Process Improvement Initiative. Our goal was to investigate areas that need further either instruction, clarification, or revisions to our current material, our public-facing material, as well as our staff training material. And our end goal is to improve the application process for applicants, for all application types, whether it's for the exams, moral character, testing accommodations, practical training of law students, and so on. And so we started this task by conducting unit by unit meetings. And at these meetings, we assessed whether there are topics or areas with a high concentration of public inquiry, calls or emails, and which for us could be an indication that there was further guidance or guidelines, instructions, or information needed in those areas. Or also assessing whether there are areas that are often misinterpreted by applicants, and as well as looking at our rules and protocols, and looking at which ones present a challenge to applicants. And during these unit assessments, we began to catalog our staff recommendations on findings, and the findings into various categories. We looked at issues that require either revisions or enhancements to the applicant instructions, revisions to the website, to the applicant portal, or perhaps incorporated into an FAQ document. Some of these also could lead to the creation of staff training or reference materials, and also potentially a rule change. So staff dug deeper on the rule changes, exploring whether the rules present a challenge to applicants, examining what the rule purpose is, and whether that rule furthers the mission of public protection. Staff also assessed whether there was alignment between the state bar rule, the corresponding rule of court, and the business and profession code. So looking alignment between all of these rules. Next slide, please. So where we are now is we are hoping, right? We now seek the CBE's input on developing a set of recommended changes. And we're going to start in these 4 areas. We have moral character, the practical training of law students, law office study, and testing accommodations. And so, we're going to provide a broad sense of what the goal is for that rule change in each of these areas. And I'll introduce each of the folks who are going to be speaking to this. But the idea is they're going to tell you what our target areas are in terms of the goals in these areas. And then we'll send a follow-up email to the CBE to solicit volunteers to work with the staff on these proposals. And I'll show you, once you hear from the staff, what that timeline looks like. So to start, I want to introduce Tara Clark, who's going to describe a little on what the goals are or the intent is with the rule changes for moral character. Tara?
Thank you, Amy. Good morning, everyone. So as you may recall, we began a review of the moral character process with the Moral Character Working Group, which convened from 2019 to 2020. The working group ultimately created several final work products, such as the Moral Character Guidelines, to provide more transparency and uniformity in the process. In 2021, staff began reviewing the admission rules relevant to moral character to ensure they are consistent, instructive, and clear. We will bring suggested revisions to the rules and the application in October. Thank you.
Thank you, Tara. And next we have Kathy Scher. She is a senior program analyst working in the programs division, and she'll be working on the practical training of law students and law office study proposed rule changes. So Kathy?
Thank you, Amy. Yeah, so I'm looking at the rules and processes for the Practical Training for Law Students program, which allows law students to get practical experience while they're still studying law, and the Law Office Study Program that allows students to sit for the bar exam after engaging in a program of legal studies in a lawyer's office or judge's chambers instead of going to a traditional law school. With regard to these two programs, the PTLS and LOS programs, one important reason that we're looking at possible revisions to the rules is that the California Supreme Court has ordered us to do so. Last fall, the court ordered the state bar to consider whether Rule 9.42 of the Rules of Court should be changed to allow students who are studying in the Law Office Study Program to participate in PTLS. More broadly, I think the goal of looking at possible rules revisions for these programs is to make sure that there are no unnecessary barriers to participation in them. As I look at the rules and the processes, I want to make sure that the processes for people who want to participate are as straightforward as they can be, that they're aligned with the applicable statutes and rules. But going beyond that, I'm also want to look at them to see if there are requirements that we have under existing rules or the processes we use that create barriers to participation that really aren't needed for purposes of public protection and making sure that the programs are well run. I am looking forward to working on this project and really glad to get the chance to talk to you about it this morning.
Thank you, Kathy. All right, and next we have Christina Dole, who's going to talk about the testing accommodation.
Good morning, everyone. I will be helping to facilitate the group that is looking for rules and policy changes, perhaps for those applicants that need accommodations for both the first year law students exam and the bar exam. The State Bar held a forum about a month, 6 weeks ago, a testing accommodations forum where applicants were able to voice their experience, share their feedback, offer suggestions on how to make the testing accommodations application process clearer. This group will be working with an ADA expert and we'll be reviewing the policies, procedures to enhance the user experience, but while also ensuring that everyone has fair access to the exams.
Right, thank you, Christina. If we can move to the next slide, please. So I mentioned that I was going to highlight the timeline here. So these are our next steps. So these are the goals that we have in mind. So the idea is between now and October, you know, as I mentioned, we're going to send out an email. We want to find volunteers who are willing to work with staff bringing a proposal to the CBE in each of these areas at the October meeting to circulate for public comment. So the idea is staff would work with the volunteer CBE members, bring the proposal to the October meeting. If the CBE were to approve, we would bring that then to the board in November at the November 2023 meeting to request to circulate for public comment. Then that would advance to a public comment period, and we would be bringing this back to the CBE from a public comment period in February of 2023. In May, it would then go from the CBE to the Board of Trustees. So the post-public comment period to the trustees in May 2023, and the Supreme Court would review in June with a potential effective date in that rule change of July 2023. So this is, again, for the first set of items. So this is, like I've highlighted, we've highlighted here, moral character, PTLS, LOS, and TA. We'll have another set of rule proposed changes for another set of areas, such as exam administration. We have other eligibility items. We have, sorry, the rest don't come to mind at the moment, but these are just our first preliminary set that are set on this timeline. So yes.
Just in case anyone's confused, the November date is 2022. There's just a typo. So that,
Oh, yeah.
so in terms of the flow of the dates, that's
Okay.
2022.
Yes, that, thank you for pointing that out. So, again, we will follow up via email. But in the meanwhile, does anybody have any questions about the areas, about our goal, or about the process?
Yes.
Oh, yes.
First of all, how wedded are you to this fast track? And I ask because I certainly self-identify as somebody who often has issues with either the major approach or the language of proposals when they first come before us, and worry that there'll be unbearable pressure to kick something out in October when, in the judgment of myself at least, it's not quite ready to go forward. First question, so let me let you answer that one, and then I have a couple more.
Well, I think our engagement with the CBE member early, like looking for our volunteers, I think the idea is to help us get to that point where we bring a product that everybody's comfortable with. So in that sense, I think we're feeling pretty confident we can do that. When we did the last rule proposal, rule, I think it's 4.19, we believe that the collaboration between the CBE member and staff really helped create a product that everybody was more comfortable with. And so we're trying to achieve that through the same process, using the same process that we use for that rule change.
Okay, fair warning, it may not work with me, but we'll see. I'm not trying to be difficult, but I'm trying to be thorough, and because we only get to visit many of these areas once, you know, and even a member who's appointed to 2 terms on the committee's lifetime, you know, that is the time I need to speak up.
Okay, understood.
My second question or comment is that while it could not possibly be on this timetable, an important revision process to me, at least, is on behalf of the Educational Standards Subcommittee, is the revision of the registered unaccredited school rules and guidelines. And I keep getting the feeling that that's being put on the back burner in favor of other things, and I will keep advancing its placement further to the front of the burners.
Yeah, that's one of the items that when I mentioned that we have another set of rule changes, that's one of the considerations as well. But you know, it's a large amount of it's a lot to tackle. Having experience with you know, the unaccredited rules revision. And it's not to say we're not going to do it. It's just it's not going to conform to this timeline. We'll be bringing that back once we start planning that in our next set of rule changes.
Okay, thanks.
Any other questions? Okay. Well, that's the last item that I have under the director's time. So thank you all for your time. Back to you, Alex.
Great. Thank you, Ms. Nunez. The next area on the agenda is examinations. Dr. Cao, I'll turn it over to you.
Thank you so much, Mr. Chair. So we'll have several things to discuss. The first item on the agenda for examinations is discussion of the Blue Ribbon Commission on the future of the bar exam recommendations and next steps. Would Alex Chen or Esther Lin be able to comment on that? Alex or Esther, are you available?
Yeah, I'm sorry. I was muted. I don't know if Esther wants to jump in first. Happy to go either way.
I'm here. Alex, why don't you take the lead?
I'm sorry? Oh, okay. Yeah, so since the last CBE meeting, the Blue Ribbon Commission has had 2 public meetings, one on July 19 and another on August 16, just a few days ago. At the July meeting, the commission considered several options, actually 7 in total, for the non-exam pathways, with each option having a different combination of program components focused on the law school curriculum, a post-law school component, and different types of assessments. These combinations sort of reflected the commission's prior discussions, and of these, the commission members selected 3 options for further discussion. And in the last meeting a few days ago, somehow the commission sort of ventured outside of those 3 options and came up with one that in many ways combines different aspects of these 3 options. In the most general sense, this option would allow bar applicants to bypass the bar exam by completing certain amount of supervised hours and then turning in a capstone portfolio of work product that is then reviewed and graded by the state bar as the sort of the regulatory body. The non-exam pathway would then be available to students. Well, we didn't really discuss, but I would assume it would be available to students at accredited or unaccredited law schools in California. But the motion to adopt this option did not pass, albeit by a narrow margin. And as far as why the motion was voted down, I think there are a number of reasons. One is that there are serious concerns about the capstone portfolio and supervised practice. For the capstone portfolio, one of the concerns is that the portfolio submitted by an applicant could include work done not only by the applicant, but also by the applicant's supervisor or colleagues that may have contributed to their work product. Now, after all, this option includes a supervised component, and so by definition, all work must be supervised by an attorney. And in practice, especially in litigation, it is almost inconceivable for a motion or brief to be wholly written by an applicant or a graduate without having it reviewed or redlined or revised by a supervising attorney or in-house attorney. Of course, there could be circumstances under which this is not true. And for certain transactional practices, this is also not true. But those circumstances are very limited and don't always reflect or align with the testing standard equivalent to a bar exam. And the commission had not studied the extent or the scope of these limited circumstances. And so members were basically asked to take a leap of faith in voting for this option. There are also other concerns with the supervised practice that I mentioned earlier because of the potential issues with fairness. The general concern is that there is a real potential for law firms and practitioners to take advantage of the opportunity to employ law school graduates for free or with minimal compensation, given the need of these graduates to fulfill their supervised hours. And those numbers floating around has been between 750 to 1,500 hours. The commission hasn't really decided what numbers is appropriate other than that there is this range. So you can imagine the unfairness that could amplify as an applicant works long hours and for these many hours. Also, with supervised practice, there is a real chance for racial and gender discrimination. This chance was confirmed when the commission studied a report regarding an alternative exam pathway that is now being adopted by the Law Society of Ontario in Canada. That study reported that almost 20% of the respondents surveyed had faced unwelcome or received unequal treatment, as well as sexual harassment. And so to ratify those issues, the Law Society of Ontario is in the process of implementing, at least based on my understanding, certain enhancements to that program, including instituting certain minimum wage or implementing audits and offering greater oversight over these potential discrimination. But these enhancements have not been discussed in any detail, nor is there any guarantee that these enhancements would similarly be implemented in California if a non-exam pathway is adopted. That probably didn't sit well with some of the members of the commission. Other concerns involve public protection. I think some members have expressed that this pathway would not protect public members. And this concern was echoed by more than 25 bar associations who have submitted a joint letter to the commission about the irreparable harm this non-exam pathway could cause to the general public. So now I talked about the first motion. There was another motion that was voted on, which recommends that California does not adopt a non-exam pathway for a license to practice law. That motion did not pass, albeit also by a narrow margin. And for those members who voted against this motion, my sense is that it was because they believe that something must be done to ratify the disproportional number of minority attorneys and attorneys of color in the legal sector. And that the current bar exam does nothing to move the needle in terms of increase in access to justice. They also believe that the current bar exam is outdated, needs to be replaced with more of the experience-based learning paradigm to align with what a lawyer actually does in the real world. So they believe in many ways a bar exam is superfluous to the work experience an applicant gains in the real world, whether during law school or after graduation. Of course, there's always this cost issue, right? With graduates getting into thousands of dollars in debts just to prepare for and take the bar exam, which certainly deepens the existing DEI issues that we have been talking about. And these issues also are echoed by many public comments the commission has received from a number of professionally licensed lawyers who have asked us to not waver, at least in our commitment, to help them achieve this attorney demographics proportionality. So with that, those are the two motions that were on the table and that was voted against the last meeting. And now I will maybe turn it to Esther in case I missed anything or anything you would like to add.
No, I think Alex summed it up pretty well. It was really a narrow margin where both motions failed to pass, but I think it was only by one vote for each. I think because there were some people who were not able to attend because it ran over, it's possible that maybe at the next meeting it might pass given more people. One of the issues that were discussed was the idea of possibly compensating the supervisors of these law student or lawyer applicants, and to what extent these supervisors would need training and what kind of training and how to regulate the supervision of these applicants. I do think that the motion for the non-exam pathway, it would have a lot of holes to fill before it can really be examined seriously. That's just a personal opinion of my own. That is pretty much all I have to add to Alex's. Does anyone have any questions or comments?
If there's no questions or comments for Alex and Esther, thank you so much for your thorough presentation and giving us an update on the Blue Ribbon Commission's current status. Moving on to item B, which is update on first year law students examination multiple choice exam content review project. Lisa, are you available to present that?
I am, and I also have our psychometrician, Chad Bugendahl. I think he's in the audience, so if he can be promoted, that would be great. Good morning, everyone. I'm here to update you on the first year law students exam multiple choice exam content review project. I was last before the committee, and I think at your June meeting to provide you with an update. Here's a further update I'll be providing. So just to kind of recap, the State Bar announced the project to review the content of the first year multiple choice exam in mid-April of 2022, seeking volunteers. We did yet ultimately end up with 13 reviewers from law schools who volunteered to help us on this project. Phase 1 was the content map review, and that was done by those 13 law school reviewers. That was completed in May of 2022, and I reported on that phase at your June meeting. So phase 2 is about to begin. We're getting ready to do that. The phase 2 is the actual item review. So I sent out an email to the same 13 reviewers who worked on the content review project. And we are in the process of gathering availability dates to try to set up those meetings. And what we are planning on doing is an initial 1-hour full group orientation and training session that will be conducted by the State Bar's psychometricians. Thereafter, subgroups of reviewers will review different sets of individual multiple choice items with State Bar staff facilitators. We're looking at 4 to 5 meetings of about 2 hours each for the first round of review. There may be a necessity for additional shorter meetings that may, where we have to revisit items that may require resolution. The meetings will be conducted remotely via Zoom with breakout rooms. And for exam security reasons, the item review cannot be done outside of those scheduled group meetings. And then next, I want to move on to kind of provide you with an update on the pilot testing that will be going on for the October 2022 first year exam. Originally in June, I had we had represented that we were going to be testing these 25 new items and that they would not be scored. The first year multiple choice exam is a 100 item exam. And we are planning to pre-test or pilot 25 new items. However, in consultation with our psychometricians, we've now decided to do that the best option is to do an operational pretest with those 25 items. And I will let Chad explain to you all what an operational pretest is.
Sure, thanks, Lisa. And thanks to the committee for hearing us today. So as Lisa said, with the first year law school exam, the concept of an operational pretest essentially says, we know that the lower bound of what we would expect for reliability can be reached with 75 questions. However, because the examination is typically given with 100 questions, those additional 25 questions provide kind of a dual opportunity. One opportunity is to start with an expectation that having gone through the appropriate development and review processes in advance, that those items will also meet the acceptable statistical characteristics. And so ideally, to be consistent with typical administrations of the first year law school exam, our goal would be to have all 100 questions operationally scored, which gives students the most opportunities to demonstrate that they know and understand these important concepts from these 3 first year law school subject areas. However, because 25 of the questions have not been pre-tested before to evaluate their statistical properties, an operational pretest reserves the right to say if any of those 25 questions do not meet statistical diagnostic quality, that they could be removed so as not to disadvantage a student by still giving them, again, the most opportunities in these subject areas to demonstrate what they know, but we don't want to hold anything against them if any of those items don't function statistically well. And so although I know it sounds like oxymoronic to say operational pretest, that's what's occurring. You start with an operational assumption that all items would be scored. You do the statistical analysis after it's been administered, and you look specifically at those 25 pretest questions. And if any of those don't function, you remove them. Now, that practice actually does apply to any of the questions if any of the questions don't meet kind of minimum statistical parameters, the program would have the opportunity to kind of remove them. But because because 75 of them have been used before, we have better knowledge of what the stability of those statistical properties are, which means we have a lot lower expectation that they wouldn't meet statistical characteristics compared to the new 25, where we know they meet the content specifications. We just don't know yet how how they will perform statistically.
Thank you, Chad. Does anyone have any questions for either me or Chad?
All right. Thank you so much, Lisa. Thank you so much, Chad. If there's no more questions for them, we will move on to item C, the discussion of report to the Supreme Court on the February 2022 California Bar Examination by Christina Dell. Christina?
Hi again. This report was brought for action to the subcommittee on examinations in July. It is brought to the CBE now for review and comment as of today. The technical report, which is included of the February bar exam, is attached. And then, of course, the exam statistics from the February exam, as well as the selected answers, which are high scoring answers, are also attached here and are posted on the State Bar website for archiving. And is there any comment or thoughts about the Supreme Court report?
Christina, this is Robbie. The report is really thorough, and I think the court will very much appreciate it. For CBE members, if you haven't looked, it actually has the bar exam attached to it, so you can see all the questions and selected top scoring answers. But Christina, it's really good. It's very thorough, and I think it's exactly what the court expects of us at the CBE to provide. So good job.
Thank you so much for that comment, Robbie, and thank you, Christina, for the presentation. The last item is item D, which is approval of the report of the 2021-2022 examination goals and accomplishments. It's the attachment 0201. I did want to comment on that, is that items 1 through 4 have been completed, and then items 5 through 10 are ongoing. It's the same items that was presented as the last meeting as well too. Are there any questions or comments for approval for the for this?
This is Robbie. I will move to approve the goals.
Thank you, Robbie. Is there anyone that can second that motion?
I will second the motion. This is Vince.
Oh, thank you so much, Vince. So the motion is approval of the report on the 2021-2022 examination goals and accomplishments. So if we can move that the report to be approved. So may we have a roll call vote, please?
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman, Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilkinson,
Yes.
and Judge Herman.
Yes. Sorry, I had my mute button on.
Thank you. The motion passes.
Thank you, Dr. Cow. Next item on the list is operations and management. Turn it over to the chair, Mr. Efting.
Thank you. So this is agenda item 0300. And it basically talks about both the actions and accomplishments over the last year and plans for next year. Most of the items are pretty much the same as before, so I don't think they need to be talked about. I just want to point out two items. Number 6, the production of the emissions training video has been deferred primarily because of issues with the COVID. And number 8, with respect to the possible review of Rule 4.17, which I believe we'll talk about later. But I don't think anything more than that needs to be specifically addressed. Unless someone has some questions, maybe we can have someone make the motion.
So moved.
Who's that?
Torres.
Thank you, Dave.
Second by Brody.
Thank you.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
and Dr. Wilcoxon.
Yes.
The motion passes.
Thank you, Mr. Epting. The next area is educational standards. I'll turn it up to the chair, Mr. Kramer.
Okay. First item is O-400. And that's action on a voluntary termination of registration as an unaccredited law school for California Southern University School of Law. This registered unaccredited correspondence law school is seeking our permission and ratification of its voluntary termination of its registration and the closure of the school, retroactive to June 30, 2022. It stopped enrolling new students in 2018. All of its JD students have completed their degrees, and the one remaining Master of Science in Law student has transferred to another school. The remaining part of the university was acquired by American Intercontinental University System, which will serve as the custodian of the law school's records. Staff recommends approval of the request. Do we have any questions? I don't know if he would be here, but is Mr. Gardner here to represent the school, and does he wish to make any comments?
Not at this time. The school has
Okay.
been very cooperative and communicative during the process.
Okay, so any questions, comments, or discussions before we have a motion?
I'll make the motion to approve.
Okay, and I guess Audrey's going to be sharing those. There's the first one. Is there a second?
Torres seconds.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilkinson.
Yes.
The motion passes.
Thank you. We're going to take 0402 and 403 together since they're essentially the same request. And those are action on extension of the waiver to teach classes online due to COVID for both Western Sierra School of Law and the People's College of Law. Western Sierra and People's are registered unaccredited fixed facility law schools located respectively in Oceanside and Los Angeles. Western Sierra is currently undergoing a periodic inspection whose results are expected to be presented to us later this year. It had 19 enrolled JD students as of last September. People's was last inspected in January of 2021, and a progress report is the next item on today's agenda. People's enrolled 23 JD students as of last September. Both schools have been teaching classes online during the pandemic under the committee-issued waivers and request permission to continue to do so for the upcoming academic year ending in August of 2023. Staff recommends that waivers be extended due to the continued presence of COVID in California and the related concerns about that. Any questions before we invite the deans to comment if they choose to? Okay, do either of the deans, Schoonover or Saranana, wish to comment?
The schools do have representatives present. The Dean of Western Sierra Law School would like to make a comment.
Okay,
Hello,
go ahead.
Dean Joshua Schoonover here. Can you hear me?
We can.
Thank you. Thank you, Mr. Kramer and the committee for taking up this matter. I just wanted to say thank you to the staff for writing up a clear description and background as well as a proposed motion. And I am available with any questions. Otherwise, I think it's a fairly straightforward matter.
Anyone else, Natalie? Thank you, sir.
No.
Okay, any additional questions for the dean or comments or discussion before we consider a motion?
Oh, Paul and Natalie, this is Robbie. I feel like most schools have returned to in-person instruction, whether public, private, all the schools I'm aware of. Is there any reason why we wouldn't ask the same of these schools?
For these two particular schools, there are certain circumstances. In the case of Western Sierra, a number of the students in this relatively small school were required to temporarily relocate due to circumstances related to COVID, and they plan to return. They plan to have the online only for a certain portion of those students. And in the case of People's College of Law, unfortunately, they experienced a situation of a passing of a professor that was of concern to people, and they have several immunocompromised individuals that reached out to the school individually. They are also a very small school. So it's a small school with a high percentage of immunocompromised individuals.
Okay, thanks, Natalie.
Any other comments or discussion?
I'll move to approve the expansion of the waiver for both schools, Western Sierra and for People's College.
Can you flip forward to the next one, Audrey? Thank you. Okay, we have a motion. Do we have a second?
This is Michael. I'll second that.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan, Alex Chan.
Yes.
Thank you. Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
thank you. Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
and Dr. Wilcoxon.
Yes.
The motion passes.
This is Judge Herman. Just one follow-up. To what extent are we looking at on an ongoing basis allowing remote learning? I know we've done it.
Sure, two fronts. So the schools have several options, and some schools have taken this path. Some have chosen to transition permanently to online learning after a good experience during the time. As for the temporary status, actually, even these schools believe that these would not be needed as of this fall. And then with the events of the summer and the uptick in the positivity rate, they changed over the course of the summer. So that is a question that the committee should think about. At what point would permanent changes be required?
Great, thank you.
Okay, the next item is O-403, action on response to notice of noncompliance by the People's College of Law. This was before the committee in June, so I'm leaving some of the details about the school out. You just considered it. At our June meeting, the committee issued a notice of noncompliance regarding 18 points of noncompliance with the applicable rules and standards. People's response to the notice is before us today for a determination as to whether it is a satisfactory response. Staff's analysis and recommendation is that while some progress has been made regarding various points of non-compliance, full compliance has not been demonstrated. Taken together with people's difficulties in maintaining compliance over the past year and the untested nature of its proposed future actions to achieve compliance, staff recommends that we find the response unsatisfactory and go to the next step in the compliance process, which would be to order an inspection of the school. And then after receipt of that inspection report, the committee will then decide whether the school is compliant or whether probation or withdrawal of registration is appropriate. Have any questions before we invite a representative of the school to speak? Do we have a representative now?
Natalie, you're on
Oh,
mute.
sorry, I'm on mute. The administrator of the school is present and available for questions. They have not raised their hand to make a public comment at this point, and they're not required to.
Okay. Well, with that, does anyone have any questions for the representative of the school?
This is Robbie. I agree with the staff recommendation to issue the notice of non-compliance. I think the bar's been very patient with the school, and we think we need to continue the process that all schools are required to abide by. So I'll make a motion to approve the staff recommendation if there's no other comment.
I just wanted to say that I was on the fence about this for a while until I read the report a lot more thoroughly. Like a lot of other colleges that we've looked at in the past couple of years, you know, the reputation of the college, you know, is a factor, especially to me, since a lot of people have come out of there and have a lot of good things to say. But, you know, looking at that report, there seems to be certain standards that were not met that we usually apply. And I'm not one to say that, okay, rules are rules, but I think that there was some time given to try to make some corrections and bring things up to standard. And so I would want to feel confident, maybe hearing this from staff, that there's a pretty good, you know, we're providing a pretty good opportunity for the school to come back up to shape in the time that's allotted.
So to address your question, Mr. Reyes, since there was a major staff change last summer at the school, and I would say that pretty much from the beginning with this school, as we do with many, we take a proactive approach. We met with the school at length on multiple occasions. We send reminders throughout the year. We do try to do what we can to prevent problems before they do occur. It's been a challenge in this school, with this school, because it is unclear that the level of staffing is sufficient in order to do the planning and execute what the school needs to do. And that's what's been the challenge here. So I feel confident that the State Bar will provide the support that's needed. And I encourage the school to do so as well.
Natalie, is it a question of funds that, they're shorthanded, or is it just a question of not being able to comply in a timely manner, even given the circumstances? And I understand the change of administration and the challenges that have come up with COVID, because certainly, we just approved an extension of remote learning.
These may be interlocking issues. The history of this school is that it has relied heavily on volunteer labor, and it has been operating as a law school for many years, decades, using this model. But in recent years, it appears that the volunteer labor that's been available has not necessarily been sufficient, and the strength of the processes have not been sufficient. The school has certainly taken steps. When they were inspected in 2020, they were using a paper system. Things were not organized. We don't expect any certain system, but they've taken steps in that regard. But there are still ways that the processes can be strengthened, ways that they can prepare for foreseeable events. If an individual is not available in the volunteer capacity or in the light staffing capacity, there doesn't seem to be anybody to step in their place. And I think that that's created a lot of problems at the school. And those events really are foreseeable, and other schools do plan for those.
Do they have any indication of what kind of outreach or recruitment they would have for volunteers to help out in this regard?
I mean, in my experience, what I've seen is that when there is a crisis point, they are able to do a call to their alumni and to get a lot of support for that period. And you did see that most recently. We've seen this now through many cycles. You saw that most recently when in the period from mid-May to mid-June, approaching this potential decision. A lot of volunteer effort materialized and a lot of changes were made without progress being made during the prior school year. So they do seem to be able to marshal quite a bit of effort and quite a bit of loyalty for a limited period of time in sort of the 4 to 12 week range. But what they really need is a consistency. And you'll see in the report here that they have indicated that they plan to hire some additional staff elements. But they're just starting now at this point, several years into the process, and so the school still seems to be very much in a reactive mode, and you don't know how they will perform and if they will solve the problem.
Okay, thank you, Natalie. I'm kind of more off the fence now and leaning towards supporting the staff's recommendation on this. So thank you for your insights.
I'm happy to entertain any questions.
Well, coincidentally, Vince, I think we're still looking for a second.
I'll second.
4 seconds.
Okay, second, Kareem. Devin?
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan, Larry Kaplan, Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilcoxon,
Yes.
and Larry Kaplan. The motion passes.
Thank you. Where am I? Next is 0404, action on the 2022 NPR compliance reporting for accredited law schools. California accredited law schools are required to maintain a 40% or greater minimum cumulative 5-year bar pass rate, or that's what the NPR is the acronym for. Those rates are reported annually in July and then to the CBE at this meeting. The NPRs for this and the previous 4 years are found on PDF page 4 of the staff report. We'll be discussing the 2 schools whose NPRs remain below 40% in the next 2 agenda items. And I'll toss it to Natalie to see if she wants to highlight any particular aspects or trends.
A couple of things to be aware of. The standards was kept the same, but for the adjustment of the provisional licensure program as the cut score was dropped for the bar exam, and the PLP alternative pathway was implemented. So you do see the effect of that. If you look at the trends over time in the attachment, you do see some of the numbers rising, possibly due to those factors, though we haven't done a specific analysis to see if the increase is attributed to that.
It could also be the lowering of the cut score, right?
It could be.
Okay, anything else?
I'm happy to entertain questions, but no further comment.
Okay, any discussion or a motion?
This is Robbie. I'll move to approve the compliance report.
This is Michael. I'll second that motion.
Thank you.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilcoxon.
Yes.
The motion passes.
Thank you. Mr. Chair, this might be a good time to take a short break if you feel that one is in order.
I was planning to take a break after the moral character and go into closed. Do you think your remaining items will go longer? Then I don't want to rush you.
Yeah, I think the next 2 might require some more discussion. I don't know.
Okay.
Committee's sense.
Oh,
the first to come up next is was the subject of most of the public comments this morning.
okay. Well, let's under that advisement, let's take a 10-minute break and then we'll return to that item. So let's take a 10-minute break and return. Thank you. Okay, welcome back, everyone. Before we jump back into the topic, Mr. Kramer, can we get a roll call vote, please? Ms. McFarland?
Yes, 1 second. Alex Lawrence,
Here.
Dr. Bolton. Dr. Bolton. Robert Brody,
Here.
Cow,
Here.
Alex Chan,
Here.
Jim Epting,
Here.
Kareem Gangora. Kareem Gangora. Dolores Heisinger. Judge Herman,
Here.
Michael Asiri,
Here.
Larry Kaplan,
Here.
Paul Kramer,
Here.
Esther Lynn,
Here.
Bethany Peak,
Here.
Vince Reyes,
Here.
David Torres. David Torres. Dr. Wilcoxon.
Here.
Circling back to Kareem Gangora. Dolores Heisinger. We have a quorum.
Thank you. Mr. Kramer?
Thank you. The next item is, by the way, somebody noticed my microphone obscuring the lower portion of my frame. Are you still hearing me okay?
Yes.
Okay, I moved it a little further away. Next item is O-405. It's action on conclusion or extension of probation or termination of accreditation and an application for registration as an unaccredited fixed facility law school for San Francisco Law School. The circumstances of this item and the next are similar. Much of what I'm about to say about San Francisco Law School, especially regarding procedure and the choice of a date that accreditation terminates, are the same. I won't repeat those thoughts when we get to the next item. Procedurally, we are in the transition period between the old and new accredited law school rules. Here, probation was imposed under the old rules, and we are continuing the process under those old rules. Under the new rules, at the end of the probation period, we would decide whether to find the school in compliance, terminate the accreditation, or extend probation if extraordinary circumstances justified an extension. The old rules, however, require that we first, at this point, state our intended action and then give the school 15 days to request a hearing before a panel of 3 committee members, after which the record of that hearing would return to this committee for final action. Staff's recommendation is that we state our intention to terminate the accreditation effective December 31st, as opposed to right now. And that's because that date gives time for an appeal hearing, should the school request one to occur, and for us to then take final action. As a precaution, should the committee ultimately decide to terminate accreditation, the school has provisionally applied for registration as an unaccredited law school. Changing the law school status of a law school from accredited to registered in the middle of a semester or quarter would create administrative complexity for both the school and bar staff and is best avoided. Thus, the choice of a December 31 date, which is between semesters or quarters, presumably. To be clear, that date was not chosen to give the schools an opportunity to show compliance based on the July bar exam results, which would come out in November roughly. Approving the request for registered status today gives certainty to the school and its students that should accreditation be terminated at a later time, the school's program can continue. And staff has reviewed that request for registration and recommends that it be provisionally approved today. In January of 2021, these are the San Francisco specific facts. San Francisco Law School was placed on probation regarding its MPR and required to bring its MPR up to 40% or greater by the 2022 MPR reporting cycle, which we just discussed a moment ago. Its MPR was 39% in 2021, but it fell to 35.4% in 2022. And earlier in 2020, it was 30.5%. So the progression was 30.5% to 39%, and then back to 35.4% most recently. That failure to get above 40% or at 40% or greater resulted in our issuance of a notice of noncompliance in October of 2020. The school requests a 2-year extension of probation to allow it 2 more annual MPR reporting cycles to demonstrate compliance, citing the effects of the pandemic and a new curriculum whose first partial beneficiaries of that new curriculum will graduate in or graduated in 2022, I guess, if they graduated in May or June. Staff's recommendation is to deny an extension of probation, to express an intention to terminate the school's accreditation on December 31st, subject to the completion of any appeal and further review of that record by the committee, and to provisionally approve the school's request to register as a non-accredited law school. Natalie, I don't know if you want to comment about the equities involved, whether it's appropriate to consider extending the probation.
Sure. We can talk about a couple of points come to mind as important. The first one is in terms of the timing of this probation. With respect to the MPR is a very core element, and as the schools are looking at their MPR each year, they do tend to have notice of what has been happening with it. In this case, while their probation period is just under 2 years, they have actually reported, underreported for 3 cycles, 2020, 2021, 2022, as you were saying. The committee offers 2 possibilities for schools, both the registered possibility and the accredited possibility. By putting forth the accredited possibility, part of what you're stating to the public is that this school is a school that can, among other things, maintain that 5-year cumulative pass rate above 40%. There is a grace period for a school that falls under for a period of time, but this school has had notice prior and 3 cycles to do so. So I think that one of the factors to consider is your responsibility as to what you are representing to the public.
Okay. Any questions for staff before we open it up to to Dean Weimer?
Natalie, this is Robbie. I don't know if this is a better question for the dean, but you're always so on top of these things. What's the relationship between the school and Allianz? It seems like this is different than one of these smaller standalone schools that, you know, as just a couple core people who own and run it. The dean's letter doesn't make it clear to me.
Okay, sure. So this school for many years was an independent school with 1 campus in San Francisco. A number of years ago, it was purchased by a larger private, now for-profit university, Alliant University. A San Diego campus was added as well. And as a result, this does afford this school some opportunities that a smaller school may not have. So for example, one decision that this school made was not to admit 1st or 2nd year classes during the time they've been on probation. So currently they only have 3L and 4L classes. And what they chose to do was to focus intensively on their 3L, their recent graduates, and then their 3L and 4L classes, as well as their alumni. And they instituted an alumni bar prep program. So that's an example of something they can do because of that backing. While their efforts didn't produce the results they hoped for this cycle, they certainly did put forth those efforts, and that's part of what you would see. We do have the president and the provost from Alliant here today, and I see that the provost already has their hand up to speak, and they may like to elaborate on that.
Okay. Any other questions? Robbie?
I wondered, Natalie, if the relationship with Alliant opened the school up to receive additional kind of financial aid programs that they wouldn't otherwise get. I couldn't tell if the dean was alluding to that in the letter.
I would suggest that we defer to the provost, who is here, to answer that question directly, with your permission, Paul.
Yes.
Okay, thank you, Natalie.
Thank you very much to the committee for the opportunity to speak. And so I'll address that question first, which is yes, we are a WASC regionally accredited institution. And so students that are with us are indeed eligible for financial aid. And I also wanted to speak to the committee a little bit about our background. As Natalie suggested, when we received our initial letter of probation, we discontinued admitting students. And we have not admitted students for the last 2 years, not because we were mandated to do so by a regulator or a creditor, but because we did not want to risk, in the best interest of students, that any student would be negatively or adversely impacted by a change in that status. So we have also made a commitment that with a 2-year extension of probationary status, we would not admit any student to the probationary program. And so this is not about enrollment or increasing enrollment. What we come to you today is about what we see as our joint obligation, really, and responsibility as both regulators and accreditors and educational institutions to protect and serve current students. And we think that's in line with the Department of Ed. It is certainly in line with WASC. So we come to you today about 18 students that are in their 3L and 4L years. 18 students who entered a program in solid accreditation standing, 18 students who deserve not to be negatively, adversely impacted, disrupted, delayed in the achievement of their degree, especially due to the fact that they are not accountable for the test-taking behaviors of their peers during a 2-year pandemic period. 18 students who we believe should have that opportunity, and Natalie spoke about the test prep, resources, individualized and group, that we will support their success in their attempt to pass the bar. We have also noted that we are going to fully scholarship their tuition and their fees for the remainder of their time. So this is not about the institution seeking enrollment. This is not about the institution seeking tuition revenue. This is really about us working together about our responsibility and obligations to protecting current students that are in a program that they entered during its good standing. So we again ask for that extension of 2-year probation, but I will take my time to say that if that is not the will of the committee, then we ask for a slightly, again, varied request. The recommendation of the committee, and we appreciate it, was December. If you extend that just 5 months until May, you allow essentially 13 4L students to complete their programs and be eligible to sit for the bar. I think that, and Dean Weimer can suggest, I think we're talking about 7 additional units by allowing that 5-month extension. And I know that the committee wished to put this off, but we have 5 students that are in a 3L year, and receiving schools for transfer are demanding an MPR waiver. So without an MPR waiver, and without a 2-year extension, these 5 students are going to be greatly adversely impacted. So we ask, if the 2-year extension is not provided, that the 4L can be served by a 5-month extension to May, and the 3L students could be served by agreement for the receiving institutions to simply waive those 5 students on their NPR exam. And so we look to partner with you and our desires to get back on good standing as a CalBAR school are entirely secondary to our joint and collaborative effort to ensure that current students, 18, 13, and 5, are not negatively adversely impacted, which we see as our joint obligation. Thank you for the opportunity to speak.
And to be clear, the nature of the impact you're talking about is that a degree from a registered school is considered to be somehow less valuable or has less weight than a degree from a California accredited school?
So I'm going to address that. I certainly want the dean or our president has joined too. I think for me, and mind you, I don't have a legal background. My understanding is there is something called the 4-year rule, and that it is not clear that all of these students would be eligible to sit based on the 4-year rule, and that calculation has not been able to be done yet. The dean can speak more. And secondly, yes, I do believe that these students entered a CalBAR accredited school, and I believe that it changes it on them, to now say, now you're not, now you're graduating from a registered school. And if we don't do the NPR exemption, the other schools are saying they won't accept the transfer agreement and credit. And so I do think as a regulator, accreditor, and institution, that changes what they signed up for. And I think that's something that we want to all stand behind in being able to do that.
Paul, may I add some staff clarification in addition?
Yeah, if you could please explain the 4-year rule and its potential application.
Sure, a couple of things. First, as to communication in the school has a responsibility to be clear with the students as to its status and as to the progression. And so the school would have been communicating with the students over the course of their time through their 1L and 2L progression, offering them the opportunity to transfer if they so choose. These students have not elected to do so. They have made me aware of at least 3 schools that have requested an NPR waiver, something that does not exist. They will only accept the students if they are not required to include these students in their NPR. But there are many other accredited law schools that have not stated that condition. So should students decide to transfer, they would not be subject to any sort of NPR waiver. There are other schools that are willing to accept these students. With respect to the 4-year rule, the way that students that are in registered programs qualify to meet the legal education portion of eligibility for the bar exam is to qualify under the 4-year rule. So to be part of a program that has 270 or more classroom hours each year for 4 years. Most likely, these students, as a matter of course, would meet those requirements. If there are some students that might have taken a reduced course load or a leave, we could work with the school if that is the case. I understand that Dean Weimer submitted transcript evaluations to the eligibility department, and it is not that there is an issue with them, it's just that it takes a few weeks to process them. But their program, whether accredited or registered, does contain the 270 hours per year for 4 years. We reviewed it as part of the registration application that you'll also see today. So I would expect that the vast majority of these students would not have any issue or only slight issue that we could remedy with them.
Without them having to retake courses or another year of study, for instance?
I can't say for certain as to each student without looking, but if there had been a significant deviation from the standard program, potentially. But that would be generally would not be the majority of the students.
Okay, so did we have other speakers on behalf of the school? I'm not looking at the
Yes.
participants, so
Paul, you are fading away in terms of volume, slowly and slowly.
oh, well, my mic has a 2-pound base, so what can assure you it wasn't moving. I'll move it a little closer, just
That's
at
better. That's
at the
much
risk
better.
of, yeah, so this is my friendly Mike, my friend, Mr. Mike. Get used to him.
Thank you, Dolores. I thought I was losing my mind. I could hear everyone so clearly except Paul. But yes, Paul, stay close.
Okay.
Oh, I have a question. With respect to some of the comments made by Dr. Heller, some of the concessions that the school is making, what type of impact would it have if we decided to provide that 5-month extension beyond what is being asked by us in this motion? Natalie, can you answer that?
Sure. The first thing to consider is precedential impact. So at this point, the committee has allowed a school to continue in operation for 3 years under standard. And it's for the committee to decide whether it should be able to extend that for additional period. And I would encourage a comment from council before thinking about that, because that is a major departure from what the committee has been saying. Since the NPR was contemplated, a 2-year window after going under 40% is what has been contemplated. So since the NPR was first started to be discussed in 2013, this would be the first time the committee is departing from that in 9 years. And it's important to remember the obligation of the school to be clear with its status with the students. This shouldn't be a surprise to any of the students at the school. For various reasons, they may have chosen to stay here, but if the school has been forthright in its duty of candor and communications to the students should be aware, and they have been talking to the students about their options to transfer and what it would mean if they stayed in a registered school. While those 3 schools might have conditions, there are many other accredited schools that won't, for those schools that those students that want to transfer away.
Thank you.
And David, extending it to May would simply allow the current 4L class that's just starting to be able to say that they graduated from an accredited law school as opposed to a registered law school, but it would not extend the time enough to allow them another NPR cycle to satisfy, or to fix their deficiency. And so we would come to May and be faced with the decision whether or not to terminate their accreditation again. So I think it only benefits the students.
Another point that came up in the discussion when we were having an internal discussion was that if you look at the progression during the time that the school has been on probation, last year its numbers went up, this year its numbers went down. At each point, the school points to further initiatives that may improve the results in the future. And so this could be a continuing cycle where you continue to give opportunities in the future. But so far, in the current period, if we look during the probation period where there really was a spotlight on producing this improvement, the results actually declined.
Okay, Mr. Chan has a question.
Yeah,
Alex?
thank you. Yes, can you hear me okay?
Yes.
Thanks, Paul. So I recalled back in 2020, I, along with Heather Jakakis and Dean Mitch Winnick, performed an inspection of the law school. At that time, the school went through several significant changes, including securing Dean Weimer and a new registrar, which at that time it was part-time. And so there were a number of moving parts that required actions on the part of the school. As part of that inspection, I spoke with students, I attended classes, and I witnessed a great well-rounded educational environment between students and faculties. And as a result of that inspection, it was recommended that certain mandatory actions be implemented. And if I remember correctly, the report also provided certain suggestions or enhance compliance with the rules, and also require San Francisco Law School to file a progress report addressing those actions that we recommended. But at the time, I was very optimistic that the school would exercise its best effort and diligence in implementing all of these actions. With that said, can you remind me, Natalie, whether the all of those actions have been substantially implemented, and if not, if what other actions that are still in progress of being implemented?
In fact, yes, they have been implemented, and per the direction of the committee, the school has been submitting periodic progress reports as to those. They've been complete, they've been candid, and they've been thorough. One of the elements, of course, was to address the NPR, and that's the one additional issue that we're considering here today. Because they made significant changes, there were certain things that they may have tried, and then after trying, adjusted, and that's a very natural process. But they have been addressing them promptly and thoroughly.
Can you remind me, and just maybe this is a bad comparison, but comparing this case against other cases, other schools that have come to us for an extension, are there any special circumstances that are present here that are not in other cases in which we have granted a similar extension?
Well, in the area of the NPR, it is not uncommon that if there is an NPR issue, there have been 2 other schools similarly situated. And in both of those schools, we saw something very similar. There was a significant change of administration. There was a significant change of curriculum. And in one case, there was a significant change of delivery from fixed facility to distance classroom, all in the hope that they would improve the NPR. Ultimately, as to the other 2, though many changes were made and many efforts were applied, the NPR did not increase, and those schools continue on as registered schools today, and continuing to have some bar exam passage challenges, but continuing to focus on that. So I would see them as similar.
Got it. With that said,
actually, I mean, the one thing that I would notice is that potentially there are significant resources, financial resources from Alliant University in this case.
Right.
But a financial resource may or may not translate into results, as we see comparing the NPR last year to this year.
But have we seen any commitment by Alliance to provide enough financial resources for the school to implement actions that are necessary to help push those efforts forward?
We have seen significant action, but in part in reaction to the response of the inspection. Previously, those resources were available at the time of the inspection, but neither the financial nor the staffing resources were made available until the inspection team made its recommendations. There also was a fund that remained unreconciled. I do see in speaking with Dr. Heller today that it seems there has been at this point a change in how the funds are allocated and how they indicate they will be allocated in the future, but this would be a change from the behavior that had been seen before.
I see. So then let me just echo one final point. I am concerned, and I echo Dr. Heller's concern about the students who are stuck in this twilight zone, especially the 13 students that won't be able to take the bar exam if we were to pass this motion. And so really the issue for me is, how do we protect these students who literally are not in any fault? And what ways can we, what actions can we consider to help these students?
Okay,
and that's
so
really the essential question for me.
So first, let's be clear that those students can take the bar exam. They likely will be able, if they stay at San Francisco Law School, to receive a JD degree on track next spring or the following spring. It would probably be of a registered character. They can graduate on time. They can take the bar exam on time. So that's not in jeopardy. There are schools that have indicated an interest in accepting or reviewing applications from these students without an NPR waiver that the committee is unlikely to grant. So they should be able to graduate from their school of choice. They should be able to transfer to an accredited school of choice. If the committee chooses to extend the time period, then I think you would balance the equities of the students in light of these other choices, the precedent of the committee, et cetera. So I just want to be clear that they can graduate on time, they can take the bar exam, and they can join the profession.
In their transcript, would the school be reflected as an accredited school or an accredited school?
It'll be reflected as to the character of the school at the time they graduate. So if the December 31st recommendation is accepted and those students graduate in May, they'll graduate from a registered school if they stay at San Francisco Law School.
Right.
Alternatively, they can transfer to another accredited law school.
Thank you. No further question for me. Appreciate it, Natalie.
Dolores?
Yes. Natalie, did I understand you to say that one of the concerns, one of the issues we would be dealing with in our decision today is setting precedent?
Yes, that's correct.
Could you say a little bit more about that?
Sure. So the idea and the concept of an NPR was discussed for a number of years before it was implemented. It was implemented and then there was a short break and it returned. And during that all of that period of time, it was contemplated that if an accredited school could not meet the 40% minimum, that they would be given no more than 2 opportunities to raise that NPR score. Here, what this school would ask is to increase that number to 4. So that would give them 5 reporting cycles over 5 years to report a substandard NPR, but still be able to hold themselves forth as an accredited law school. That would be a change from the 2 to the 5. I'm sorry, 2 to the 4, 5 cycles.
Thank you.
Okay, did we have anything else from the law school, Natalie?
We do. We do have continued hands from the law school.
Dean Weimer. Go ahead.
Okay, thank you very much. I really do appreciate the discussion today in regards to our accreditation. Of course, this is important, so I appreciate the committee taking the time. I would like to address the concern in the report and recommendation about the NPR going up and then going down. And I think it is evidence of something that I hope I can put in context here briefly. As Mr. Chen had stated, he came for our inspection and there was a list of things that we began working on to improve our overall program, to improve our compliance. And we have demonstrated that through our reports every 6 months. And if you recall, in the June meeting, the report that we submitted and was accepted by this committee stated that we are now in 100% compliance and have been in continued compliance with the exception of the NPR for the last 6 months, because that's the period between the 2 reports. So there is evidence that we have been working very diligently and have taken action and have done the things this committee and the state bar requirements are asking of us. We have made those improvements and that's been acknowledged in the reports we've submitted. But one thing I want to clarify here is to why our NPR score went down overall. The class of 2020, which would have been the first graduating class to benefit from any of the incremental changes we have been making, actually had a 40% first-time taker pass rate, which was an improvement. And that's why our scores went up. It was evidence that what we were doing was working. We expected it to go up again with the class of 2021, but we have to distinguish our actual student demographics are very unique in that 90 to 95% of our students are full-time working adults in their mid to late 30s with generally 2 to 5 children ages 5 to 15. That's not your typical law school student. And so when the pandemic hit, when we say, yeah, COVID had a negative impact, we understand that across all of the law schools, it had an impact. But when you have 90% of our student body that fits into a group that was severely impacted, because now you have a breadwinner who is forced back to their house to do their work, possibility of losing their jobs, and some of our students did lose jobs. Their family, their children are now no longer going to school, but pushed back into the house because they can't go to school. After that 8-hour day of trying to work and helps their children through their school, now they're going to have to attend an online lecture with their kids in the background and the dog and all those other distractions. They didn't have the opportunity to get to the school and their a good learning environment. Add to that because these are older adults coming to school, many of our students had parents that fell into the 65 plus age range. Some of our students actually care for these their older parents. Add now the stress of this pandemic particular to that age group and our students having to care and watch out for their older parents. The stress that the class of 2021 experienced was much different and very unique for a set of law school students, because our demographic, 90% of our students fit that. It's not the late 20s and single or newly married student. It's a working adult with families and all those pressures. And it played out. The class of 2021, after 18 months of the pandemic and being online and facing those stressors, now has to take the bar exam. And so they did not do very well. And it brought the MPR for the 5 years down. So I think we have evidence to show that what we were doing was working. Our class of 2020, we started to see the improvements. We now have 18 months of a pandemic before the next class really has an opportunity to try to take the bar exam. A very unique demographic of students here, and they were very uniquely impacted. We're not saying other schools weren't impacted. We're saying our student body is very unique in that it was one demographic that really felt the stresses. So I hope that from the reports we've submitted, you can see that we have done everything possible. The university has committed an immense amount of money and resources as well to help our alumni from the previous graduating classes. We now have this bar assistance program that's open to all of our alumni. And it's very important for us not to just focus on the current students we have or our revised program going forward, but also to ensure that those who have graduated before we were here with the improvements, to give them an opportunity to really be prepared for the exam as well. So I hope that I've addressed some of the concerns that have been brought up. We have shown that we've made improvements. That's been reported. It's been acknowledged by this committee.
Dean Weimer,
and
that's 5
we can
minutes.
very clearly, well, thank you for your time. I just wanted to address those concerns.
Thank you. Was there anyone else, Natalie?
I see the president of the university, Andy Vaughn.
Yeah, I think our protocol, Alex, was generally 2 people.
2, correct.
So are you open to letting the president speak for, say, 2 minutes?
Yes, and then I believe, if there's any other discussion or questions from the group, then we can go to a motion. But yes.
Okay.
Thank you, everyone. Can you hear me okay?
Yes.
Okay. Thank you to the committee for our consideration here. Just want to underscore a couple of things. The schools that are close to us geographically, we've been talking to about transfer, are the ones requiring the waiver. The schools, at least in my knowledge, that would not require that would require the students to move. So what we're really asking for in our extension request is to minimally disrupt the 18 students that we have in the 2 classes. You do have our commitment that we will no longer enroll new students for the next 2 years. That will continue. As Dr. Heller stated, we will also be scholarshiping the students for all tuition and fees to continue their program. Our goal is to do no harm to the students. And so I know that Natalie mentioned there are some schools not requiring the waiver they could transfer to, but in my knowledge, I might be wrong in this. Maybe Dean Weimer could speak up on that issue, but I think that would require a geographic move, which is not going to be possible for those students. We would like to take care of the 18 remaining students in the 2 classes. You have our promise to do everything that we can, both financially and resource-wise, with support academically and bar prep, to make sure they have a successful finish. But that really is our goal. We are a large university system with 8 different campuses across California, Mexico, and Arizona. And so for us, it's not a question of needing students to enroll into law school to be sustainable. We have the resources to make sure all 18 students are taken care of, and you do have our promise we will do just that. So thank you again for your time.
Thank you. Okay, do we have any more questions of staff or comments or discussion?
I see a question from Dolores.
Okay, go ahead, Dolores. You're muted.
Yeah, I had my hand, I never took my hand down, so
Okay.
that was an old one.
Okay, if I might just address a couple of the comments that were made, Paul.
Please go ahead.
Yeah, so I do believe that President Vaughn talked about the schools that were geographically in his area. Many of these other accredited schools are in a distance modality, and it would not require the students to move. And this school has been operating until this spring on a distance waiver. So these students would be used to distance classes. And then in addition, during this period of time that the school has been on probation, as a reminder, the profile demographic that the school described is the profile demographic of the registered and accredited schools in general. And we actually saw, rather than a decrease, an increase for many of these schools with a similar demographic during that time period. So I think that that's something to be aware of, and to put forth an extension for this school. It would make it challenging as to whether or not you could deny an extension for any other school, with the basis simply being that the students prefer to graduate from an accredited school, and they still have that option before them.
Okay, Mr. Brody, unless you're just going to make a motion, and then we should hear from Mr. Chan first.
I am just going to make a motion, so Mr. Brody Chan can go first.
I am a strong advocate for following rules for accredited law schools. That is not a hidden secret. Without rules, the CBE cannot function, nor could it make consistent, informed decision. But in this instance, I understand the impact of COVID on working students who are also parents. It puts a tremendous amount of stress on students and parents who are also struggling to meet their work obligations. Let's be very clear, there is no justification for law school to not comply with our rules governing NPR. But I am pleased with the improvement and the substantial compliance with our mandatory action items. Unlike many other schools that have come to us that have done little to complete our action items or giving us any comfort or evidence that it was doing all it could to improve its legal education. So with that said, I do believe, and I was going to make another motion, but I guess, Robbie, you can make your motion first, but I'm hoping that the committee would consider the circumstances here that are somewhat different from other situations, other schools that have come to us, right? We're optimistic the school has done enough, and it is still making more efforts and contributing resources to making further progress. And so I want to make sure, we consider all of these external factors in making our choices. So with that, I'll pass the mic back to Brody.
Dolores, did you have a comment first?
Yes. Yes, I am not muted. Okay, so I feel the same way that Alex does, a bit conflicted here. I understand the need and importance of rules and of potentially setting precedents that we have to live with at some point in the future. But I agree with Alex that in this instance, everything I heard from the school, from university, it's very compelling, very compelling testimony. The fact that they want to put their students ahead of anything else, that they promise not to enroll any new students during this time period. That's a big commitment, and certainly something that in the future would help with any kind of precedent setting that this would provide. If schools in the future that would seek an extension would be willing to make the same commitment, I think that, you know, that would be considered also, but I don't see that happening with very many of the schools. I don't think many of the schools can afford to do that. So I'm leaning very, very heavily in favor of the schools at this point.
Okay, thank you. Mr. Gongora and Mr. Chan, did you mean to have your hand up still?
Thank you. Thank you, Paul. So I'm also very sympathetic to the school's explanation and to Mr. Chan and Dolores's comments as well. I had a question on procedurally, what are the potential outcomes if we go to an extension?
If you go to an extension, are you thinking of a 2-year extension as requested by the school?
Yeah, I mean, from what I've heard from the school, they're really intentional and working towards providing the support and resources to the students, which is something that I really commend, considering the circumstances and our past couple of years have been really strong and difficult for our communities. But yeah, more or less a 2-year.
Okay, so that would result in a 4-year probation for them.
Okay.
They would have, the committee could decide one more opportunity, 23 only, or 2 more opportunities, 2023, 2024. That's what they've asked for, to come up to that 40% period. And then the committee would then evaluate what they're reporting at that time. It sounds like there might be some thought that the committee would place the condition that the school already represented, that they not be allowed to admit additional students or transfer students during that time. And that would be monitored along the way as well.
I have a question, Natalie, regarding what is within the committee's purview to have updates or to make recommendations on a annual basis and do extensions. Is that seen as not recommended, or in your professional opinion, is the 2-year what would be sufficient or insufficient?
Here, ultimately, it's at the committee's discretion rather than staff's. You can place additional conditions along the way. So if you want certain reporting, not only as to the MPR as itself, but also as to the steps that the school is taking along the way, you can make that part of the probation condition.
Okay.
Yes, and you would be representing that this school, out of compliance for up to 6 reporting cycles, is in fact an accredited school.
Okay, and it, I know we changed our rules a bit, but the school would have to be in communication with the students and post out publicly that they're in that process, or is that something not required?
They would, and they have been. They have been doing that very consistently.
Okay, Natalie, thank you as always, and yeah, I hope we could consider some type of alternative to provide support to these students and to the school's plan.
Mr. Reyes.
Yes, thank you for those clarifications, Natalie, around options and how to monitor the progress towards, getting back on track. But, these are pretty extraordinary times. And I think a lot of the things we're doing are kind of linked together. So, we have the PLP program, which was extraordinary that was even able to happen in such a short period of time. We've done accommodations around taking the bar so that that could be done online. And then the extension of online classes for a number of schools. So I kind of think in these times, all of these things are linked towards how can we best protect the ability of students to go to law school and to graduate. And according to the school itself, even, you know, I don't think the students are going to get harmed in any way. They still will be able to graduate and to take the bar. So that given that I'm, you know, very sympathetic with the school and the protection of the students, but I do agree that there has to be pretty close monitoring around this. It's you know, we're making an exception, but we're also looking at this, the baseline of making our exception is based on what we've done in the past for other schools. And I do agree with Alex. I'm a strong believer in the rules, but these times maybe, and what we've done in the past couple of years regarding the situation we're in around COVID, make me feel more confident that we can, you know, make these exceptions for this particular school, but with close monitoring attached to it. So.
Okay, any further questions before I turn it over to Mr. Brody for a motion? Okay, Mr. Brody.
And, you know, from the time I first raised my hand till I listened to the comments of my colleagues, I've come around a little bit. I started out I start every meeting. I want to be fair. I want to be fair to every student and to every law school and apply our rules in the same way to everyone. But the comments from Dolores, Kareem, Vince have made me think I'm going to make this motion that we approve the extension of time with the proviso that the school not admit any additional students until the requirements are met. Natalie, is that an acceptable?
Is it possible to have that put on screen?
Yeah, we're just between Natalie and I revising what was in the agenda item. So she's going to share something that we can amend.
And was that for 2 years, Mr. Brody?
I suppose so.
And
so we're giving the school additional time that we have never afforded another school, and which is not our rule, but we're taking some extraordinary circumstances into account, including these existing ongoing students.
I think it would be good to address in the actual motion or make some reference to the special circumstances, because future generations, when they look back, will have to otherwise review this recording in order to figure out why we did it. And that's not very helpful for them.
And I agree. And both, CBE members, we're departing from the rules on which schools rely in their practices. And this school is a 4-year commitment for students, and it's not free. The tuition is almost $100 grand. So, public protection is our number one. I want to make sure we're protecting these students, which is why my motion does not account for admitting new students. I want to do the right thing for these existing students, but then that's it. We need to see these improvements, particularly with a school that is part of an umbrella of a bigger institution with more money and resources, things that we don't see at People's College or other of these small, owner, the dean owns the school and there's 2 teachers. This is not that. So, wow, you know, that you fellow members, you really swung me to be a little bit more expansive here, because I'm thinking about those existing students and I'd like to see them graduate, you know, with their heads held high with their accredited school. But after that, that's it. I would hate for a new prospective student to commit to 100,000 and all of that time for a school that cannot get it together. It's not fair. Then we're not doing our job. So my motion is.
Mr. Brody, I think what Paul was also indicating was whether or not there were other concessions too that we have to consider because of the COVID. There may have had an impact on both the school and the students as well.
Yeah, Mr. Brody, I just added this. This is going to be citable precedent, if you will.
Right.
So the extent to which we can make this, we can cite the special circumstances that are leading us to this position, I think is important to be placed in detail, including, you know, the last 2 years of COVID, the efforts that have been made, especially the restrictions and oversight over the 2-year period, and the restrictions in terms of taking additional students. I mean, I think we need a bit of a punch list. So
I agree, Judge. And Natalie, I don't want the CBE to make it hard for you to do your job, which is interacting with all of these schools and telling them these are our rules. So yeah, if we can make this, I think that the CBE is behind this kind of motion. I'm just guessing, taking the temperature of the room, that we want to accommodate these students. So yeah, is there any, can you prepare that motion in a way that takes into the judges all of our concerns?
I am preparing it as we speak, and I have a couple of questions and a couple of points just to make clear. Sometimes when people graduate, they do not take the bar exam right away, or their results will not be included in the MPR that you see. And so the students that are graduating in 2023, 2024 may not immediately show up in the MPR results. What I might suggest is a moment for me to consider and lay that out for you, only for the purpose of memorializing it correctly in the motion, perhaps bring it back a little bit later in the meeting.
I agree with that. I just wanted to kind of comment on what Judge Herman said. I think there needs to be some pretty strict deadlines, because I think, COVID is going to be around a long time and we don't know how it evolves. And, that shouldn't, it's present. Sometimes it's legitimate to make changes, but I also don't think it should be precedent for anytime something goes wrong, it's because it's COVID. So I think it's because of the integrity of the school and what they want to do to protect their own students. That's my main motivation for supporting the extension for this particular school. So if somehow that kind of oversight is built into the motion, then I'd be very,
and I think that
comfortable.
Alex Chan also elaborated on a variety of reasons why he was supporting the school. Alex, are there any other issues that you can think of or conditions that you can think of that we can place in this motion?
Not that I'm aware of. The school really has done a lot to comply with our rules substantially. And so I don't have anything negative to say about any non-compliance.
If I might just make the counter argument, just for the sake of being a devil's advocate, perhaps. Other schools have gone through these same situations. I think we're making an assumption that somehow the demographics of this school are so different without really having researched it. So I'm a little bit reluctant to assume that this student body was so differently affected by COVID than those at other schools. And if you look at the MPR report again, most schools stayed at about the same place, and some improved, some declined a little bit, but yeah, and of course they were all over 40%, with the exception of this and the next one. And what's my other point? Yeah, these students are not going to be prevented from passing the bar. It is simply the character of the law school that shows up on their diploma, whether it's a registered or California accredited law school. That's what's going to change. And if that is a problem for them, they do have the ability to transfer. So, I mean, I just, in the face of all the other counter arguments, I just wanted to make sure we remember those.
I think it may be helpful for the committee to consider the point I was saying I needed a moment to consider. I took that moment. So the MPR that you're looking for at right now, that includes students that graduated through July 31st, 2021. So certainly by July of 2021, the pandemic was in fact in full swing, and probably those students that took that bar exam or those applicants were going through that period. If you give an extension of probation, next year's MPR will be through graduate class 2022, some of whom you heard from this morning. And then the 2-year extension will have the class of 2023, the class of 13 that Dr. Heller mentioned today. So you won't actually be giving these 2 classes that have had the benefit of the full 4-year curriculum an opportunity to show their results in the bar results. You'll actually be giving these 2 classes an opportunity to graduate from an accredited school, which you may, without transferring, which you may decide to do. So I just wanted to make the time period clear, just to realize that you may be in this position in 2 years of the school saying, well, as I told you back 2 years ago, these 2 classes were the first to benefit, and we would like an additional year or 2 so that both of these 2 classes can be represented in the MPR. So that's something to think about. Another thing to think about is how you will compare to other schools, such as one coming up just next, that did not have to make the extraordinary compliance leaps and bounds that SFLS did in the last couple of years, because they did in fact establish compliance and maintain it other than the MPR. And so query how you will treat those schools differently. I also have a question for council. Something else that was represented was that these schools would be scholarshiped, and I believe you could notice that in the motion, but is that something that the State Bar can condition, or I'm not sure if the committee would even intend to make that condition as part of the special circumstances that Judge Herman talked about documenting?
The committee can decide what it wants to include as conditions. I think the committee members who have identified the fact that this case would be one where the committee makes specific findings that extraordinary circumstances justify the extension. The more detail we want to include on that, the better for purposes of precedent and guidance to future schools. So that is what I would recommend.
Yeah, I would say it's one thing. It might be a harder case for us to require it had the school not proposed it, but having the school propose it as a part of the package, then we're simply saying, hey, you have to live up to the promises you made to us as a condition of getting this extra relief from the committee. Mr. Gangori, if you have your hand up.
Oh, I was going to ask for the motion if there were any monitoring or additional oversight that that was requested or recommended. I don't know if it's impedes or if it provides us an analysis, but 6 to 12 months updates, or Natalie, if you think that's not efficient or not helpful. I guess I was just trying to make sure we were covering our bases.
Well, this is kind of a binary issue. Are you at 40% or not? So does anything else matter? Like how they're working towards it?
Yeah.
I mean, you might ask for an update about the efforts they're putting toward bar exam prep. In particular, you might ask them to demonstrate the part exam results. or the per exam results parsed in terms of those takers that would be part of the MPR. Those things might be possible.
And how would we use that information? Perhaps to reduce the extension of probation, or? 'Cause
If
Cream,
to, yeah.
Cream has a point that if we're just looking at a report with no possible effect on the result, it is taking agenda time only.
Yeah.
Mr.
I mean, I
Efner?
think that's probably true.
We're covering a whole lot and it's kind of, I'm feeling crammed. Does this decision have to be made today? Can be put off to the next meeting?
Timing wise, then we might get forced into making the termination effective at the end of the spring, or the next year's first semester, because if they invoke their appeal rights, it might be hard to have the hearing and get it back to us for our December meeting. Is that fair, Natalie?
Well, it certainly would be less time, but if we know at this point that that could be the case, then we can plan ahead for that, and that can work, remaining with the December date or choosing a later date if the extension is granted.
But if the committee is generally thinking about granting them more time anyway, the fact that we're going to kick this over to the next meeting, give everybody a little more time to think about it, process it, I don't say that that's a lot of harm. And I personally would like a little more time before I vote yes or no in this one. My thoughts.
Okay, anyone else? Natalie, you were working on some kind of motion, or do
I
we need,
am.
as someone suggested, to perhaps consider the next item and then come back to see your draft?
I would suggest that we look at where I am going to see if you are comfortable, you collectively are comfortable. I'm editing this portion here, that the extension would be granted through 2024 with a proviso that the law school not admit any other students beyond those currently enrolled unless and until the law school demonstrates that it has in turn earned a compliant 2023 or 2024 MPR as accepted by the committee. This finding is based upon extraordinary circumstances that exist due to the pandemic, and then perhaps and to the efforts the law school has made to establish and sustain compliance and to provide these students with financial and educational support.
I mean, we're
Something like
basically
that.
saying, with that reference to their maintaining compliance, we're saying you get credit for following the rules, which to me doesn't make sense. But I'd suggest that you focus on the efforts to support the students and improve their performance. And also, if it's granted,
I think Paul froze for a moment. We'll welcome him back in a moment.
Ugh,
There he is.
there, okay, am I here?
Paul, we lost you, but you're back.
Okay, yeah, I've got an unstable internet connection again. I'm going to shut off my video. That might help. So anyway, did you get any of that?
Unfortunately, I did not.
Okay, so I think talking about their coming into and maintaining compliance on all the other issues, that implies we're giving people credit for, following the rules, and I don't know that that's when that's ever appropriate. I would suggest focusing on the efforts that they are making to support their students and improve their performance on the exam. And then as far as the ending date, when you say through 2024, that means that the first time we could consider, if they still are unable to get to 40, the first time we could consider taking further action would be in early 2025. And that is quite an extension, I think, longer than we were talking about. So maybe you have to set a date. I'm not sure July 31st works well. Maybe it has to be the end of August, because we have to wait for that 2024 NPR report. And just personally, I would reluctantly support a 1-year extension, but I don't know that I can support a 2-year extension.
Paul, you may not be able to tell, but Dr. Wilcoxon has his hand up.
Oh, thanks. Go ahead, Dr. Wilcoxon.
Yes, Paul, I'm concerned too. I support students 100%, but it's up to the academic institution to take the responsibility to make sure that they remain in compliance so that the students can meet their goals. I'm curious, Natalie, the year that the school mentioned they had the drop in their scores, did they offer that class any type of assistance with studying for the bar? Do you know?
I think that because we have the benefit of the dean here, I would suggest recognizing him for an additional minute on that question.
Yes, go ahead.
Thank you.
Dean Weimer.
To answer that question, yes, we started not quite 2 years ago what we call our bar preparation assistance program for our alumni, and the class of 2021 was one of the first groups that we implemented that in with additional workshops and things over the summer. Again, this is to all alumni, but the class of 2021 did have access to that assistance program.
Any other questions, Dr. Wilcoxon?
Yeah, so that was one of my main concerns. If they did offer the assistance and the scores did not go up, even though that was a challenging year for their students, I'm not sure if I would recommend the large extension that we're talking about. The most I would be comfortable is with you, Paul, is 1 year, and that's still a little bit reluctant. Thank you.
Hey, this is Robbie. If I can amend my motion to be a 1-year time frame, and I know, Natalie, we're putting you under the gun here to prepare it, but I would like to vote. We've had a great deal of public comment on this school in preparation for today, and I'd like to be able to give some closure to it. I mean, this is a robust discussion, which is what I like about the CBE. I mean, we're all contributing and minds are changing, and people are being very thoughtful. So I say let's keep going and see if we can have a motion that will meet the majority of the CBE's approval. How are you doing there, Natalie?
I'd like to show you what I have in line with the adjustment that you just described. I'm highlighting it in gray. Can everyone see my screen?
Yes.
Does this reflect the motion that you wish to propose, Judge Birdie?
I'm just taking a closer look.
Of course. And would you like me to make it a larger font?
No,
You know,
okay,
the bar at the bottom right, Natalie, to enlarge the document.
Do you see it?
Yeah.
Oh, there we go. Because this is my motion, I'm going to go ahead and read it. So we'll move that the San Francisco Law School's request for an extension of time to complete the requirements of its probation be granted through the reporting of the NPR in 2023, with the proviso that the law school not admit any other students beyond those currently enrolled, unless and until the law school demonstrates that it has earned a compliant 2023 NPR as accepted by the committee. The committee makes a finding that an extension is appropriate because extraordinary circumstances exist due to the pandemic and to the efforts, recognizing the efforts of the law school to provide these students with extraordinary financial and education support in the form of full scholarships and educational support for all enrolled JD students through the law school's return to compliance. So committee members, this is awfully specific. For another law school to try to use this, they'd have to agree to provide the education for free, among other things that we include here. Paul, does that seem to encompass the discussion we've all been having?
Yeah, just as an editor, the words in the form of, in the line there, the finding, Natalie, I think you should know up. Provide these students in the form of extraordinary financial. I think you should just say, provide these students extraordinary financial and education support. And then I think you could simplify that to say the committee finds rather than makes a finding.
You can delete the that as well.
Okay, all right.
And then
Paul, I leave
Paul-
this, sorry, Paul, I just
Oh.
want to mention one thing, is that it says plans to provide. We might want to change that to commits to provide, but I leave that to you.
Yeah, that's probably better, because we're making it clear that making it more clear, I suppose, that we are expecting them to follow through on that, and that's a big part of this.
Mhm.
So I don't think you have to read it again, Robbie, but does that work for you? Is that your motion?
Yes, I suppose we're jumping through a lot of hoops here to
Oh,
accomplish.
okay, what about this last line?
Is this still needed, in your opinion, if it is a 1 year?
Yeah, because we're using the old rules, we just can't have anything sort of automatically occur. We have to notice them and all that.
And you may wish to keep this portion of the motion. Oh, wow. Okay. That just further requires notice to the students as they have been giving.
Right, so delete the two above it. Okay, and this does not include the concept of periodic reports, which is, from my comments, you can gather, I don't think would serve any purpose, but I don't know if anybody is still interested in that.
Well, I'm happy with this as it is. Let's see if there's any support. Is there any second for this motion?
I'll second. This is Kareem.
Roll call.
Alex Lawrence,
We abstain.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri. Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak,
Yes.
Vince Reyes,
Yes.
David Torres, Dr. Wilcoxon.
Yes.
Circling back to David Torres. The motion passes.
Okay, thank you. Mr. Chair, the next one is so much like this, I think it makes sense unless somebody's about to die of malnutrition to go forward.
All right. Do you think, because like we are losing just a couple of people because of calls they have to make, can we break at 12:30?
I doubt we'll get through this one. Maybe we
So-
should just wait.
So,
then.
yeah, so let's break now for 30 minutes and return and have a working lunch. If that is okay, see people nodding their heads. Yes, that's great. So let's return at 12:50 and then we will jump right back into that item G for ed standards. Thank you, everyone.
And I appreciate the committee's efforts in helping me to edit on the fly.
Thank you, Ms. Leonard. Okay, Vince, you win the first prize. There we go.
What's up, Alex?
Lunch, working lunch.
Working lunch indeed.
Yep. We're doing good stuff.
For
on a
you, that was
Friday.
probably 2 or 3 grapes, but
I've got an apple waiting for me when I go off camera.
I know you.
We'll give it another minute, see people are still coming back, and then we'll do a roll call.
Yeah, I'm ready. I'm just going to leave my video off for bandwidth issues.
Sure, that's fine.
Oh, I sent you a message about your race.
Some guys thought it was a race, but I didn't.
Okay. Got a couple of text messages from a couple other people. They're here. Miss McFarland, can you go ahead and do roll call?
Alex Lawrence,
Yes, here.
Dr. Bolton, Robert Brody,
Here.
Dr. Cow,
Here.
Alex Chan, Alex Chan, Jim Efting,
Here.
Kareem Gungora, Kareem Gungora, Dolores Heisinger,
Here.
Judge Herman, Judge Herman, Michael Asiri,
Here.
Larry Kaplan, Larry Kaplan, Paul Kramer,
Here.
Esther Lynn, here, Bethany Peak, Bethany Peak, Vince Reyes,
Here, here.
David Torres, Dr. Wilcoxon,
Here.
circling back to Dr. Bolton.
Here. Did you hear me?
I did, thank you. Alex Chan, Kareem Gungora, Judge Herman, Larry Kaplan, Bethany Peak, David Torres. With 11 members, we have quorum.
The Kareem's here, by the way.
Thank you.
Thank you, Ms.
Yeah.
McFarland. I'll return it over to the chair, Mr. Kramer.
Jim Herman here as well.
Thank you.
Okay, next one is 0406. Action on conclusion or extension of probation or termination of accreditation and application for registration as an unaccredited fixed facility law school. And this one is combined with a waiver to teach classes online due to COVID. It's for Lincoln Law School of San Jose. Please recall what I said about procedure and the choice of a termination date for the previous item. They apply equally to this one. Like the previous school, Lincoln Law School was placed on probation in January of 2021 and required to bring its NPR into compliance by the 2022 report we discussed earlier today. That report shows that they remain below the standard at 36.1% in 2022, down from 36.5% in 2021, but up from 31.5% in 2020. And it was in 2020, October to be specific, that we issued our notice of noncompliance. Lincoln is requesting an extension of their probationary period for 1 year to allow additional time for them to come into compliance, citing improvements to their curriculum and an upward trend in their NPR. As an alternative, it requests that we allow it to prove compliance with the results of the July bar exam when they are released later this year. As I said earlier, the choice of a December 31 termination date in the staff's recommendation was not made to allow them to make such a demonstration, but rather to allow the appeal process under the old rules to complete and for administrative convenience for both the bar and the school by not changing the status of the school in the middle of a teaching semester. Under our rules, the NPR is calculated only once a year in July following the release of the February exam results, not in December. Staff believes that 2 NPR cycles is reasonable and finds the justification for an extension of probation to not have been shown by the school. They recommend that both the proposed extensions, the 1 year and the alternate to allow the July results to be taken into effect and to account to be denied, and that we give notice of the committee's intention to terminate accreditation effective December 31st, 2022, which would allow time for the school to request an appeal hearing and for the committee to consider final action once the record of the appeal hearing, if one is requested, is available. As with the previous school, Lincoln makes a precautionary request to register as a non-accredited school. Staff reviewed that request and recommends that it be provisionally approved, again, to give certainty to the school and its students that teaching may continue if accreditation is ultimately terminated. And then Lincoln added an additional request for a waiver to continue to teach classes online due to COVID. And I believe that would be for the academic year that is upcoming or has just started. So it would end August 31st of 2023. And for the same reasons that were given for the earlier approvals, staff recommends that the request to teach online be approved. Do we have any questions before we hear from the school representatives? I see no raised hands. Natalie, can you tell us who is here for the school?
Yes, we have Dean Laura Palazzolo, who is ready to be recognized.
Okay, Dean Palazzolo. Do you have 5 minutes under our protocol?
Thank you, members of the committee. 2 years ago, I predicted Lincoln would find a way to get 20 of our graduates past the bar exam at a time when our record would have indicated that was impossible. We came incredibly close, missed by just 2 students. It was interesting for me to hear this morning that there were about 21% fewer applicants for the July 2022 bar exam. This is consistent with our experience and validates our sense that we might have met our goal in more normal times with more of our graduates taking the exam. I echo Dean Weimer's comments regarding the effect of the pandemic on our unique demographics. We included a study, you may recall, in our response. Nevertheless, you might have sensed from our papers, I'm very proud of the progress we've made and look forward to continuing along this positive trajectory until our bar pass rate exceeds that of many of our ABA peers. As a small school, we've invested significant resources in improving the success of our most recent graduates, and I think the numbers bear that out. I don't think an extension under these circumstances does set a precedent because of the pandemic and our unique demographics. The committee has discretion exactly for circumstances like this. As is no doubt apparent from our papers, I think the school that we were 3 years ago perhaps should have been here, but the school that we are today and the students that we have today don't deserve it. San Francisco expressed a similar sentiment. We've missed the mark with the time we had. We've asked for more time to avoid disruption and to keep the focus firmly on our progress. I do hope you'll grant that. And if we have to promise not to enroll students before we reach 40%, I will put that before my board. Perhaps one concession that would make that easier for a small school like us would be for the committee to review our 2023 compliance in June rather than August, so we can see to class with some certainty when we do show compliance, which I'm confident we will. I hope our fourth year students who are similarly situated will not be treated differently because we do not have the resources of Alliant. We really have directed significant resources, both administrative and financial, toward our student success relative to our size. And I think our students' success rates show that. I want to end my remarks by just thanking you for the time that you invest so that schools like ours, both registered and accredited, can exist to help fill the gaps in access to justice throughout our great state. Staff has also been very proactive through this process and it's much appreciated. And obviously I'm here to address any questions. Thank you.
Are there any questions for the dean?
Robbie?
Robbie.
I don't have any questions for the dean. I'm just going to make my comments, which are these. I don't see the extraordinary circumstances presented by the law school we just discussed. I guess I just want to remind our committee that this is not a freebie school. The current tuition is $88,000. It's almost $100,000. So and the time commitment for these students, where the likelihood is very small that they're going to be successful on the bar exam. So absent other comments, I'm going to make a motion to approve the staff recommendation here as written.
Okay. Let's see if there are any other comments first. Is that okay with you?
Yeah, I don't see any other hands. That's why.
Okay, so you were expressing an intention to make a motion. Before he does that, does anyone else have any comments they wish to make or questions for the dean?
I just have a question about how many students we're talking about in the 3L, 4L.
Our 4L class has 8 students. Our 3L class has 10, so approximately the same number of students as San Francisco.
And then Dean Palazzolo, could you remind us how many are in your 1L and 2L class as well?
Our 1L class has 25 students currently. Our 2L class has 20.
Thank you.
Okay, I guess we're ready for a motion.
Then this is Robbie. I'm going to make a motion to approve the staff recommendation as written. Paul, do you need me to read it?
My latest thought is no. Does council disagree?
No, it's fine.
It's on the screen.
That is my motion. Would anyone second it?
James Bolton, second.
Thank you, Dr. Bolton. Okay, well, Paul.
Yes, I'm Devin, roll call.
Alex Lawrence,
Abstain.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Efting.
Can you pass me?
Sure. Kareem Gangora,
Yes.
Dolores Heisinger,
Abstain.
Judge Herman,
Abstain.
Michael Asiri,
Yes.
Larry Kaplan. Larry Kaplan. Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak. Bethany Peak. Vince Reyes,
Yes.
David Torres. David Torres. Dr. Wilcoxon,
Yes.
Jim Epstein,
I think I'm going to abstain too.
Larry Kaplan, Bethany Peak. The motion passes.
Okay, thank you. Scroll down to the next one. Okay, this is a action on an inspection related to a notice of non-compliance for American Heritage University School of Law. The attachment is O-407. American Heritage School of Law is a for-profit, registered, unaccredited distance learning law school headquartered in Rancho Cucamonga with 11 students in its JD program as of last September, and they reported 20 students in May of this year. Its 2021 MPR equivalent was 12.5%. It has experienced significant attrition, and the 2020 and 2021 fourth-year classes had one student each. American Heritage was initially inspected in December 2020. After a lengthy follow-up period, the inspection report contained 29 recommendations to achieve compliance with our applicable rules and standards. A warning letter was issued in December 2021, followed by a notice of non-compliance in March of this year. No response to the warning letter was received, and the response to the notice of non-compliance was 2 months late. At our June meeting, the committee ordered an inspection, which would be the next step after determining that the response was not satisfactory. And that inspection was conducted on July 21 by Natalie Leonard and Dr. Wilcoxon. The inspection report is for the committee today. If we find that the report demonstrates that the school is not likely in compliance or likely to be in compliance, we are to notify the school that we are recommending probation or withdrawal of registration. Following a period in which the school may request an appeal hearing and the completion of any such hearing, we will then consider taking final action on the basis of the complete record, including the record generated during the appeal hearing. Throughout this process, the school has failed to satisfactorily respond regarding 17 of the initial inspection's 29 recommendations. It has failed, for example, to make its financial personnel available to answer staff's questions at several meetings or conferences, the questions being about the school's finances, or to clarify the status of the school's ownership. Staff is recommending that the school be found not in compliance, and a notice of our intention to place the school on probation or terminate its registration be given to the school. Do we have any questions before we call in a representative from the school? Robbie?
Well, this is Robbie. I do have some comments, but I wanted to hear Dr. Wilcoxon. I know you've got a bird's eye view of this one. I wanted to hear your comments first before I started blabbing.
Thank you, Robbie. We visited this school a month ago, maybe a little over a month ago, and I was concerned with what they had not accomplished based on what we recommended. What really concerned me is the individuals that needed to be there to give us the facts, like the financial director, was not present. they had consulted the responsibilities to an outside source, but that individual was not there either. So I'm just concerned that that's just one example I'm sharing with you, that the school is not taking our recommendations serious and placing the needed attention onto it to be a better service to their students in our community.
Thank you. Is there someone here from the school today, Natalie, to present?
I don't believe so. We did notify the school verbally and in writing. I'm just going to double check because there is one member of the public who is identified by telephone in case that is a member from the school, but they are not indicating that they are. So I don't believe there's a school representative.
Okay, let's ask if there is a representative in the participants room, raise your hand either by using the icon on your screen if you're using your computer, or pressing star 6 or 9, star 9 on your telephone.
I don't see a representative.
Okay.
Hearing none, then I'm going to say, you know, I've evolved a lot in my years on CBE, and one of the things that I became mindful of was law schools in maybe underrepresented communities like this one. This is out in Rancho Cucamonga. But as distance learning has become more and more prevalent among these schools, I'm less bummed out about that. I'm more concerned about schools not taking students' money and time when they're not delivering the product that they say that they are, like this school. So I'm going to go ahead then and make a motion to approve the staff recommendation, particularly now that I've heard from Dr. Wilcoxon. I think that that is does not serve a school well to be unprepared when the CBE, who's all about trying to make it work, schedules something and they are non-responsive. So my motion is, well, here it is on the screen, to adopt the staff recommendation here.
This is Don, I second.
Roll call vote.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan, Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak, Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilcoxon,
Yes.
circling back to Larry Kaplan, and Bethany Peak. The motion passes.
Okay, thank you. The next item is administrative updates from our accredited and unaccredited law schools. It's attachment 0-408 or O-408. I don't really have anything to say about it. It sort of stands on its own, but Natalie may want to highlight a couple of points. So go ahead.
Sure, just to let the committee know, in the interest of time, one thing we've started to do with the administrative updates is not only to indicate when a new dean or registrar joins, but if there are administrative points of compliance. So for example, if a name change is implemented or if a branch campus opens on schedule, we'll include these in here so that you have that monitoring touch point efficiently.
Okay, thank you. No motion is required. Does anyone have any questions or want to discuss anything? Okay, moving on to our final item in Ed Standards, and that's 0409, the approval of the report on 2021 to 22 educational standards, goals, and accomplishments. I didn't have any, well, I have one thing to highlight or ask a question of staff about. And that's goal, let me find it, number 9, I believe, the last one. Sorry, goal 10, which, no. Hold on. It's the one about, no, did we get rid of the one about trying to convert the registered schools to accredited schools?
I believe that that's still on the list, but there is not a timeline associated. And part of what has been going on in the meantime is allowing whatever natural movement occurs as a result of COVID, pandemic-related circumstances, and also the implementation of the new accredited law school rules. So I believe that remains a goal without a timeline associated to it during that adjustment.
No, I think it fell off here.
Oh my, I'll double check, but it should not be so unless unless you move so.
No, but anyway, my thought about that was that this goal was created so long ago that I wonder if any of us remember, it wasn't necessarily created at our issue, but our level. But I wonder if we shouldn't maybe just discuss it at some point in the future, just to understand what the ramifications are. For instance, if registered schools, yes, had to become on accredited schools and were subject to the NPR, we just dealt with an example of somebody who would be, way below the required NPR score. What effect is that going to have on the availability of legal education? If it's none of our business, maybe we should be, learn why that's the case. But it just seems like a policy that's been out there for so long that maybe we need to revisit it, not necessarily to change it, but to understand it, to the extent it informs our other work.
That's so noted. And something else that might be of interest to you is that the registered schools calculate on their web disclosure a slightly modified version of a cumulative bar pass rate. So we do have that information. And if that's something the committee would like to see, we can share it with you.
Are other folks interested?
This is Robbie. I would be interested to see that, yes.
Okay, I don't know if it's, you need to make it, put it on a future agenda, or if you can just circulate that. I'll leave that to staff to determine the appropriate approach.
Okay, thank you.
Any other questions or comments about the goals?
This is Robbie. I'm going to say that, it's the hardest working subcommittee on the CBE, and my hat is off to you, Paul, and of course always to you, Natalie, for being so thorough. As some things have been relegated or delegated to staff only, this is one component of the CBE that in which our members take an active part, and it's quite time consuming, and it's very much appreciated, those of you that have the laboring oars each time. So thank you very much. And having said that, I'm going to move that the goals and accomplishments report be approved.
I'm going to second it. This is Taurus, and based upon Robbie's comment, I guess he wants to chair this committee this coming year.
Hardly.
Okay, we have a second. Roll call.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak, Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilcoxon,
Yes.
and back to Bethany Peak. The motion passes.
Okay, thank you. I just want to say, give my thanks to the subcommittee members, especially to Vice Chair Dr. Wilcoxon for their service this year, and to him for stepping in for me last year when I was beating myself up on my, or last meeting when I was beating myself up on my bicycle. And we look forward to a as productive a new year. So thank you, and Ed Standards is done.
Thank you, Educational Standards. The next item on our list is moral character. Mr. Reyes.
Thank you, Alex. First of all, thanks. We are on track with our plan, thanks to the staff, to Tara and company. We're pretty much at the middle of the year and we are on time. Things that are coming up, of course, as discussed earlier, is looking at the admissions rules and how these will apply to moral character. So that's coming up in October. And then we will, to round up the rest of the year, continue our kind of internal education and talk again about bias and how that will affect our decisions going forward. So that's about it. It's we're right on track. So looking for a motion, unless there's any questions.
Is there a motion?
This is Robbie. I'll hats off to you, Vince, for shepherding us all through this. I'll move to approve the moral character goals and accomplishments report.
So move, Mr. Chair.
Dolores, a second.
James Bowles, a second.
Alex Lawrence,
Yes.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Dr. Cow,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Yes.
Dolores Heisinger,
Yes.
Judge Herman,
Yes.
Michael Asiri,
Yes.
Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Esther Lynn,
Yes.
Bethany Peak, Vince Reyes,
Yes.
David Torres,
Yes.
Dr. Wilcoxon.
Yes.
The motion passes.
Thank you. So that concludes the open session. For the committee members, please leave the open session and join the closed session. You should have received an email this morning from Ms. Ching with the subject line closed session, August 19, 2022 CBE meeting. So please leave this and join the closed session right now. Thank you.
This is Judge Herman. I believe that you may have sent it to my court address rather than my personal address because I have not received it.
Do you have the other email, Devin?
Yes, I do.
Okay.
I'll get that to you, Audrey.
Devin will forward.
All right. Thanks.
All right.
Thanks so much.
Thank you, everyone. Okay, welcome back to open session. Meeting business has concluded. Is there any more business? David, Mr. Torres?
Thank you very much for your service, Alex. You're a fine leader.
Thank you. Hey, all of you makes the job a lot easier. So thank you so much. Appreciate that support. And good luck to Mr. Kramer and Dr. Cal in the year ahead in their service time. And for everyone, have a great weekend.
Bye-bye.
Bye-bye.
Bye, everybody.
Thank you. Bye.